be extended for the commissioner file his report, Your Lordship.
Okay, learned advocate for the decree holder is present. As because the learned special officer has not filed the report, the time to file the report stands extended till 25/9/2025.
Number 9.
I hear on behalf of the respondent. Rather than this matter, my lord,
Respondent judgment data
respondent judgment data, my lord,
is for the decree holder.
not appearing today,
But
but
let it be passed over then.
I'll just indicate, my lord, in any event, I'm enjoying an order of stay from the appeal court. Lordship may recall my appeal had been dismissed, but that has been restored and the interim order is back in operation.
Like pass it over.
As it pleases your lordship.
I'm just passing it over. The passport.
Number 10.
Well, this is my application, my execution application.
GA1 is whose application?
G1 is ours. GA2, my lord,
GA2 is your application.
is my application.
GA1 is also my application.
G1 is also my application, but your lordship is concerned primarily with GA2 right now. My lord, in this matter, my lord, I had entered into an agreement for sale in respect of the subject property in 1979. Thereafter, my lord, the person who sold the property to me, my lord, was not executing the conveyance deed in my favor. Therefore, my lord, I had to file a suit, my lord, for specific performance. Decree was passed in my favor. Even after the decree was passed, my lord, the property seller, my lord, was still not executing the conveyance deed.
GA2.
Yes, and then I was forced to file, my lord, an execution application, my lord, asking, my lord, the registrar of this original side, my lord, to execute the conveyance deed in terms of the decree. Lordship, on an earlier occasion, my lord, had directed, my lord, the matter to go before the stamp collector for assessment of how much stamp duty will be payable.
The last order. Registered report assessment of stamp duty is already done.
Yes,
And stamp duty is assessed at 10,64,000 for unit 12 and
Yes.
17,94,000 for unit 13
that's right, my lord.
at the suit property. At the
The two suit properties, my lord,
total is 20 lakh
28 lakh 58
8,940.
949.
This is the report.
This is the report, my lord.
Yes.
My lord, one submission, my lord, only one place, my lord, I join issue, my lord, out here so far as this report is concerned. This report, my lord, and this assessment has been done on the basis of the present market value
Yes.
of the two properties, my lord. My respectful submission before your lordship, my lord, is that the stamp collector, my lord, should have assessed it, my lord, on the basis, my lord, of what it was.
Now, here, the
Yes.
question is, this cannot sit in appeal over the assessment. You have a separate forum. I can grant you that liberty to move the collector or to move an appeal against this order. If you
Right.
want, I can grant you that liberty. Come after the case.
I'll just take, kindly give me one more. Valuation, so this is the whole problem. You have to challenge that. Go into that whole thing.
See, either you accept it or you.
Yes, because the difficulty which the client is facing is the date of assessment.
Very well, I'm granting you that liberty because
Then, my lord, will go into a different spin.
I'm keeping it after vacation. You take necessary steps. I'll grant you that liberty. Because
Yes.
this court cannot go into merits of that, whether the assessment is done.
No, only thing is what I'm requesting this court to do is, my lord, to direct, my lord, that the assessment should be done as on the date of, my lord, when the purchase was done, and not as on the market value, as not on the current date.
Question is, you see, the agreement was entered into and on which date?
1979, 12th February 1979.
And the suit was filed in which year?
Suit was filed in 2007 and decree is of 2016. So, my lord, naturally, my lord, the value of the property has increased substantially.
When the defendant was due to execute the sale deed.
In 1979 itself, the moment I paid the full consideration.
Record an order. Learned advocate for the decree holder is present. In terms of order dated 26th August 2025. 26th August. In terms of the order of this court, the assessment of stamp duty is done by the collector of Kolkata, Stamp and Revenue. Learned advocate, the decree holder submits that stamp duty is assessed as per the current market value of the suit property, but stamp duty ought to have been collected on the basis of the market value of the property existing in the year 1979. The facts and circumstances matter stands adjourned till 4/11/2025. The collector of Kolkata Stamp and Revenue is directed to consider the assessment of stamp duty of the suit property as per the market value existing during 1979, upon giving the petitioner decree holder an opportunity of being heard. Let this matter appear on 4/11/2025 for report of the collector of Kolkata Stamp and Revenue.
I'm most grateful, my lord.
Item number 11.
The award holder, my lord, will see my lord's last order of 2nd September. Their appeal
Lordship,
was
of the
dismissed. The
judgment letter.
judgment letter was to come with instruction as to how they will make.
Lordship, I have taken instructions. Lordship, the bank has gone for an appeal. However, my instruction is that we are willing to pay the amount within a period of 6 weeks, but that is subject to the order of the Honorable
Let them
Supreme
make
Court.
payment within 6 weeks.
I shall
subject
make
to-
yes.
Subject to the, and my lord keeps it up after six weeks. Kindly seize the last order. ঠিক আছে, এখন বলছে they are going to make payment in 6 weeks.
Yes, so I granted that opportunity
Yes.
to make the payment or obtain an order from the higher.
Yes.
We have preferred an appeal, Lordship, but my instruction is that we are willing to pay the amount. We
Preferred an appeal against this order.
this no against the order of the
Division bench, we
division
have not
bench.
been served. Be that as it may, today my learned friend says that his client is willing to make
We are
payment in
willing
6
to make
weeks.
the payment.
So kindly records that in case of default in payment of 6 weeks, my lord, consequential orders in execution would follow.
However, that is, Lordship, subject to the order of the
You can obtain an order of stay, then that's a different issue.
that,
different
yes, Lordship.
Unless you obtain an order of stay, you have
Not
to
sure.
pay that amount.
Lordship, if my
How much
The
you're willing to
total
pay?
amount, my lord,
Lordship, as per my report, it was around 89 rupees, but the
How much are you?
139, Lordship, the entire
decretal
amount.
entire decretal amount.
The entire
It's
amount.
more than 4 crores, 25 lakhs.
How much you will pay?
We are willing to pay the entire amount.
Learned advocate for the decree holder and learned advocate for the judgment data are present. By order dated 2nd September 2025, were granted opportunity to take necessary instructions to the compliance of the stop. Learned advocate for the decree holder submits that an appeal is preferred before the Honorable Supreme Court, but her client is ready and willing the facts and circumstances. Opportunity is granted to the judgment debtor to make the payment on or before 4/11/2025. Let this matter appear on. This is 6 weeks means after vacation.
Revocation, Lordship.
Let this matter appear on 4/11/2025 under the same heading.
Grateful.
Let me kindly record for recording compliance on that day.
Under the same heading for necessary compliance.
Grateful, my lord.
No further adjournment will be granted unless necessary orders are obtained from the appeal court.
Grateful, my
Grateful,
lord.
Lord.
Deeply obliged.
Number 12.
My lord, I am appearing for the decree holder in this matter. My lord, I am humbly praying for an adjournment,
Judgment data.
but I am humbly praying for an adjournment. Let it appear anytime after the vacation. My lord, only one thing I want to point out before my lord, they have filed an affidavit of asset pursuant to my lord's order. My lord, that is not in proper form. I am not willing to.
One thing, I do one thing. I keep it after vacation, you go for mediation. You see, if it is can be
My lord, that already took place and it failed.
take place.
My lord, the mediation has already taken place.
When the order for mediation was passed.
My lord, pursuant to appellate court's order, there's an appeal pending. Pursuant to appellate court's order, we held a mediation. A mediation was held between the parties before the mediator appointed by this honorable High Court. My lord, that has failed, my lord. My lord, let it appear anytime after the vacation.
After vacation, kindly keep
Learned
it, my lord.
advocates for the parties are present. On the prayer of the learned advocates, the matter stands adjourned till 4/11/2025.
Publishment.
Item number 13.
My lord, I appear for the decree holder in this matter. My lord, kindly takes the last order passed by your lordship, my lord, in this matter. Order dated, my lord, 21st of August 2025. In fact, I have prepared a short compilation which has all the documents, my lord. এটা দিন, এটা সুবিধা হবে। এটা রাখুন।
The state of West Bengal is a party here.
Now, my lord, possibly
Interim order is there.
attachment of the bank account. Now, my lord, they said that they have preferred my lord SLP. Kindly takes the compilation which I had just now, my lord, made over. My lord, that compilation.
Just pass it over. Let the others.
So, my lord, kindly just takes note of the order, my lord. I don't think.
I'll take it up. I'm just passing it over in the first call.
কালকে রাখবো। Notice দিয়ে আসি। My lord, in that case, may I give notice to Mr. Sinha and come back tomorrow? Or day after tomorrow, whenever lordship takes chamber business.
Yeah. Learned advocate.
Kindly records that the SLP has been dismissed. I have produced the order, my lord.
Definitely. Then you see, this court is not powerless. Learned advocate for the decree holder is present. None appears for the judgment data. It is submitted by the decree holder that the special leave petition filed by the judgment data is dismissed.
On 29th August 2025.
9th August 2025.
Yes, ma'am.
However, as none appears for the judgment data, in the interest of justice, the matter stands adjourned till
Day after tomorrow, my lord.
11/9/2025. No further adjournment will be granted.
Grateful, my lord. My lord, kindly also records I have filed that compilation, my lord.
Compilation file be kept with the record.
Grateful, my lord. 11 তারিখ মানে হচ্ছে পরশু। Very grateful, my lord.
On the last occasion, lordship was pleased to grant me leave to file an application for rectification. I have already taken out the master plan. Not given.
Okay, just make it. I'm just making it not today.
Yes, lordship, that's
Not today.
My lord, I will for the receiver, my lord,
Item 14.
item to file report, my lord.
Okay, learned advocate for the petitioner.
Yes.
Petitioner degree holder and learned special officer is present. Let the report filed by the special officer be kept with the record.
Copy.
So I'm keeping it next Tuesday. Let this matter appear on 16/9/2025.
But the main difficulty is in the returnable date has been given on
Okay.
11.
Let this matter appear on 11/9/2025. Possible that take the ticket. Okay, I'm sorry.
Possible matter, item number 7.
Not today.
Item number 9.
Lordship, on the last occasion, it was the first
Item
one.
9, you are for?
I'm for the judgment data.
The holder is not here. I'm making it not today.
Lordship.
Yes.
Item number 2.
Yes, my lord, I appear for the defend numbers 1 and 2.
No, item number 2.
Oh, sorry. 10th. Oh,
In this
sorry.
matter, I appear for the respondent in GA2 and for the petitioner in GA5.
Your lordship, I appear for the plaintiff decree. I am led by Mr. Senior Advocate Devnath Ghosh, your lordship.
GA2 is whose application?
GA2 is their application,
Maharata.
GA5 is GA2 is an application under chapter 13A
13A,
and
there is
GA5 is an application. Lordship,
under for
Then
extension of
let
time.
it be not today.
Lordship, in that event, make it not this week, then next week.
Actually, not this week.
Lordship.
Item 2 and 3, not this week. It will appear in the usual course under the
Lordship,
chamber
Lordship,
application
Lordship.
heading. Not this week. Correct.
If not, I'm opposing this.
Yes, my application.
Addressing, and I hope my junior will address. Order 7, Rule 11, they were addressing.
Yes, rejection of plaint application filed by the different numbers 1 and 2. But two issues mainly. First is, my lord, it is the widow of late Arun Bhutoria, my lord, who has filed the suit in 2012. Now, my lord, pursuant to leave granted in 2017, my lord, the plaint filed in the present suit was amended. But I'll show your lordships the order first. But kindly see, my lord, page 19 of my application, that is GA11.
Page 19.
Yes. Yes, page 19 of GA11. But this is the order. In terms whereof the plaint filed in 2012 was amended. But kindly see, my lord, page 20. The relevant portion of the order, my lord, page 20, the second paragraph, which starts with the words, my lord, under such circumstances. My lord, the next page. Page 19, my lord, the order starts. The relevant portion is at page 20. Yes. But kindly see, under such circumstances, there shall be an order in terms of prayer A, B, and C. The department shall carry out the amendment within 2 weeks from date. A copy of the amended plaint shall be served upon Mr. Such and Such within 2 weeks after reopening. Now, my lord, kindly see, my lord, page annexure B, that is page 21 onwards, which is, my lord, the amended plaint. In fact, my lordship straight away comes to, my lord, page 55 onwards. The cost title is quite long. My lord, the body of the plaint, my lord, it starts at page 83. Yes. But apart from the defendants who were already there on record, post the amendment. Yes, page 83, my lord, the body of the plaint starts. But kindly see, my lord, apart from initially, my lord, there were 34 defendants. Now, my lord, pursuant to the amendment being allowed on 27th of April 2017, my lord, the heirs of Arun Bhutoria were also added as defendants by the widow of Arun Bhutoria, who is the plaintiff in the suit. But kindly see on page 83 itself, your lordship will find. But kindly see, the last defendant was Vanguard Holdings Private Limited, who was the original defendant number 34 in the suit filed in 2012. Now, but kindly see, there is a handwritten endorsement on the self-same page. But 35, Kanta Devi Bhutoria, the mother of Arun Bhutoria, was impleaded post the amendment in 2017. Yes, next is Mala Jagrit Bhutoria, one of the sons. 37, Rajit Bhutoria, one of the sons. And Mala Rajesh Kumar Pandey, who is an outsider who has been impleaded. So, Mala, the widow impleads the mother, the two sons, post the amendment being granted pursuant to the order of 27th of April 2017. Now, Mala, kindly see the reliefs claimed. But kindly takes the second volume of the application. But kindly comes to page 159 onwards. original plain টা বার করে রাখো পুরো annexure দেওয়া yes my lord, kindly takes the second volume of the application second volume or it's a short volume not so thick page 159 where is the original plain with annexures yes
So this is the volume to page 151.
well, I am at page 159
159.
yes but kindly see the first prayer decree for partition of the estates and property mentioned in schedule being annexure E hereof amongst the plaintiff and the defendant numbers 35 to 37 in accordance with the shares of the parties as stated in para 48 hereof by meets and bounds or otherwise as the honorable court may deem fit and proper. Now, annexure E. Kindly, Lordship has the original plaint with the annexures.
This is the volume. Volume.
But on the last occasion, my lord, we had given a copy of the plaint with the annexures. Copy of the plaint with the annexures. In my application, we have. No. Copy we had given a copy. But the plaint that we have annexed is without annexures. Now, my lord, we have also relying on the annexures of the plaint. But may I hand over a copy, my lord, of the plaint file with annexures? It is. That's annexure E. Because the reason why the first prayer relates to partition of the assets and properties mentioned in the schedule, which is annexure E. But that is annexure E.
Annexure E of the plaint.
Yes. Yes. But kindly see the next prayer. Decree for declaration that the equity shares, particulars whereof, have been given in Schedule A2 hereof are properties and assets belonging to the plaintiff. So, in essence, a decree for declaration has been prayed for in respect of the shares which belong to the husband of the deceased. Now, she is claiming a partition of the shares which is not permissible. Widow, admittedly on the basis of the documents disclosed along with the plaint, is neither a shareholder nor a director in the companies who have been implicated from different numbers 4 to 34. Yes. But since I had drawn your lordship, I have drawn your lordship's attention to prayer AB of the reliefs claimed, but kindly see the pleadings in support thereof. But kindly takes the first
Prayer A and B.
AB, no, not AB, page 159, prayer AB.
Yes, AB.
Decree for declaration that the equity shares, particulars hereof are given in Schedule A2, hereof are properties and assets belong to the plaintiff's husband. So, in essence, the relief is that there should be a declaration that the equity shares held by all those companies belong to the husband of the plaintiff. Now, kindly see the pleading vis-a-vis prayer AB. My lordship kindly takes the first volume of the petition, page 129. I am at para 40 capital D of the plaint.
129.
First volume of the application. Kindly see page 129, para 40 capital D. Yes, but this is very important. Kindly see in view of the aforesaid, but kindly see from page 127 onwards. I'm sorry, Kindly see from page 127, para 40C, 40 capital C. The two paragraphs are connected with each other. Now, kindly see 40C. The plaintiff states that several of the properties are standing in the name of the defendant numbers 3 to 34. Now, my lord, admittedly, 3 to 34 are companies which have been implicated in the present suit as defendants. The shares of and in the said defendant numbers such and such were almost to the entirety held by late Arun Bhutoria. Defendant numbers 1, 2, and 30, and by way of cross holding between the defendant numbers 3 to 34. The particulars of shareholding of the defendant numbers 3 to 34 will appear from a schedule annexed A2 and marked with the annexure A2.
What is the contention of the plaintiff? That
Contention is
property standing in the names of defendant number 3 to 34.
but the shares 3 to 34 are companies which have been implicated as defendants. Now the contention is that the shares of these companies were held by her husband. The second line of para 40C, shares of and in the said defendant numbers 3 to 34 were almost to the entirely held by Arun Kumar Bhutoria. So that's the assertion made in the plaint, that all the shares or entirety of the shares of all these companies were held by the husband of the widow. Now kindly see, she gives particulars of the shareholding of defendant numbers 3 to 34 will appear from a schedule annexed A2 and marked with annexure A2. Now kindly see page 129. The aforesaid manner of cross-holding of shares is evidence of the fact that the defendant numbers 3 to 34 were in control of Arun Bhutoria and the persons who are holding shares of such companies in trust and for the page 129,
Yes.
which is a continuation of para 40 capital C.
Yes.
Kindly see the aforesaid manner of cross-holding of shares is evidence of the fact that the defendant numbers 3 to 34 were in control of Arun Bhutoria, late Arun Bhutoria, and the persons who are holding shares of such companies in trust and for the benefit of late Arun Bhutoria and after his death for his heirs. Several immovable properties standing in the name of the defendant numbers 3 to 34 have all been given in schedule E to the plain. That's page 69 that I had shown to your lordship. The incorporation of the defendant numbers 3 to 34 were only to have a corporate veil, whereas the true beneficiaries of the immovable properties was late Arun Bhutoria. After his death, they stand for the benefit of his heirs. Now kindly see the next paragraph 40D. In view of the aforesaid, the plaintiff has claimed rights to the extent of her 1/4 share in the said properties. Now kindly note, these properties admittedly on the basis of the plaint case stand in the name of the companies. 40 capital D.
You are representing which defendant?
Defendant numbers 1 and 2.
1 and 2. Are you a limited company or?
No, I'm individual. I'm an individual.
Yes, 40D.
Kindly see, any in event and in the alternative, the plaintiff is entitled to claim and claims 1/4 right in respect of the, this is very important, 1/4 right in respect of the equity shares of and in the said defendant numbers 3 to 34, particulars whereof have been given in the schedule annexed A2 and marked with 1A2. Similar two situations that arise. The first one is that rights have been claimed in respect of immovable assets of companies which have been implemented as defendant numbers 3 to 34. This is the first part. Second part is rights have been asserted on the basis of equity shares of the plaintiff's husband in the companies which were implemented or which are implemented as defendant numbers 3 to 34. So two issues. Partition in respect of assets held by companies, partition in respect of shares held by companies. But this is not permissible. But prayer A at prayer capital A, I'm sorry.
Which relief is barred by law? Any particular relief or any?
The entire plaint. Because if the entire plaint is barred by law, only in that case the plaint can be rejected. There cannot be any part rejection of plaint.
Which relief is barred by?
Now I'll show one by one. The genesis of the pleadings made in the plaint is that the widow has now acquired rights vis-a-vis the assets of the company, widow has acquired rights in respect of the shares held by the company. Now, importantly, my lord, a shareholder at the end of the day, my lord, cannot assert any right in respect of the immovable assets of the company. So if the shareholder does not have any right in respect of an immovable asset of the company, the shareholder cannot claim partition. Even if she has 1/5, even if she has half, 50% of the shares, shareholder, if the shareholder does not have any right qua the asset of the company, the question of a decree of partition does not and cannot arise. Yes. So this is one more situation. This was in respect of the immovable asset. Now there cannot be any decree for partition in respect of the equity shares held by Malad, the widow's husband. Widow does not have any shares. Malad, there is a schedule which has been disclosed along with the annexures, Malad, prepared by the plaintiff herself, wherein she has herself admitted that she is neither a director nor a shareholder in these companies. That is the defend numbers 3 to 34. Kindly gives me one judgment I'll cite.
I was just observing. Light colored jacket was traditional long time back. My father says in his days, chamber judge would be carrying a light colored jacket.
But we usually think twice before wearing all
Yes,
this.
I was so I've only heard
Usually,
this.
we usually
Think
we do not
twice.
move so casually. We usually think twice.
But this is
Before taking this step,
I,
think twice and then we take this.
I must tell my father this. Well, this is I've heard even I'm told there's a Wish Banerjee also possibly would sit in light colored jacket.
I did not have any opportunity because his lordship used to sit in the division bench.
I have also not seen. I have seen just the Wish Banerjee division bench only. Oh, it's a single bench I've seen in writ court and residuary, but not in interlocutory court. This is something to remember.
Yes, but since I had coined the issue, but whether a shareholder will at all have any right in respect of the immovable assets of the company, but this is very much well settled. But kindly see, but this is now, my lord, we have SCC from 1950 onwards. This is 1954, volume 2 Supreme Court cases, page 563. This is the landmark Bachaev Gazdar judgment. But I am relying on, my lord, paras 10 and 11 of this judgment. Yeah. Yes, my lord. This is 1954, 2 Supreme Court cases, 563. Yes, but kindly see, my lord, para 10. Para 10. Yes. Yes, I'll just place para 10. But the interest of a shareholder vis-a-vis the company was explained in Charanjit Lal Chaudhary versus Union of India. That judgment negatives the position taken up on behalf of the appellant that a shareholder has got a right in the property in the company. So the proposition that was coined that shareholder has a right, that was negative by the judgment. It is true that the shareholders of a company have the sole determining voice in administering the affairs of the company and are entitled to, as provided by the Articles of Association, to declare that dividends should be distributed out of the profits of the company to the shareholders. But the interest of the shareholder, either individually or collectively, does not amount to more than a right to participate in the profits of the company. The company is a juristic person and is distinct from the shareholders. It is the company which owns, very important, it is the company which owns the property and not the shareholders. The dividend is a share of profits declared by the company as liable to be distributed amongst the shareholders. Now kindly see, my lord, very important, company owns the property. Shareholders do not. Company owns the property. So if today, my lord, if the widow or the plaintiff, who is the wife of late Arun Bhutoria, my lord, asserts rights, that she has rights qua the immovable property is held by the company, then, my lord, such right is not recognized by law.
Question is, this judgment was passed in which jurisdiction?
Yes.
In which jurisdiction or
No, my lord,
suit jurisdiction?
I'll just see the
It
facts.
was with regard to any suit or with regard to any writ?
Agricultural income, yes. Kindly similar the first paragraph of the judgment. This was relating to a tax issue
Yes.
that ultimately went up to the Supreme Court, where one of the
Between the individual and the tax authorities and regarding the property. Okay.
yes,
The question is, anyway, the point of law that is observed there in that paragraph.
yes. Kindly see para 11 also, my lord. Para 11. But reliance is placed on behalf of the appellant on the passage in Barclays Companies Act 12th edition, page 894, where etymological meaning of dividend is given as dividendum, the total divisible sum, but in its ordinary sense, it means the sum paid and received as the quotient forming the share of the divisible sum payable to the recipient. This statement does not justify the contention that shareholders are owners of a divisible sum, or that they are owners of the property of the company. The proper approach to the solution of the question is to concentrate on the plain words of the definition of agricultural income, which connects in no uncertain language revenue with the land from which it directly springs, and stray observation in a case which has no bearing on the present situation does not advance the solution of the question. There is nothing in Indian law to warrant the assumption that a shareholder, this is very important, I'll lay stress on these words. There is nothing in Indian law to warrant the assumption that a shareholder who buys shares buys any interest in the property of the company, which is a juristic person entirely distinct from the shareholders. The true position of a shareholder is that on buying a shares, an investor becomes entitled to participate in the profits of the company in which he holds the shares, if and when the company declares, subject to the articles of association, that the profits or any portion thereof should be distributed by way of dividends amongst the shareholder. He has undoubtedly a further right to participate in the assets of the company, which would be left over after winding up, but not in the assets as a whole, as per Lord and Anderson puts it. But very clearly it has been explained that shareholder, my lord, once he buys the shares, the shareholder is only entitled to the dividends if declared by the company. Because ultimately your lordship will see, my lord, the charge holder on the assets of the company will be the company's creditors. Because at the instance of a creditor, if a proceeding for winding up or proceeding before the bankrupt under the bankruptcy code is initiated, ultimately if the assets of the companies are sold, now the first right to receive benefit will be the creditors. Now, my lord, under the IBC, my lord, your lordship has seen, my lord, post admission of a petition under section 7 and 9, it is the financial creditors who are only included in the committee of creditors. The operational creditors have given us secure creditors, workmen, and even the waterfall mechanism provides that first payment has to be made to the creditors, barring the other insolvency resolution costs. But that is the reason why.
Any other?
Yes, my lord, there is a recent 2025. There is a recent 2025 SCC, about 2025 1 SC 456. I'm sorry, my lord. Yes. Then, my lord, the next issue, but kindly see, my lord, again. My lordship, kindly see. I'll go to take your lordship to the remaining reliefs. Yes, my lordship kindly comes back to page 159 once again. The remaining reliefs. sum and substance is falls from the rights in respect of the shares held by the deceased. Sum and substance is in respect of the right held by the or if in the immovables of the companies. The issue that boils down is whether the widow can at all have any right in respect of the equity shares held by the companies. That's number one. And number two is that
Your grounds for order 7 rule 11, is it that the relief is barred under law or the plaintiff does not disclose the cause of action?
reliefs are both. Both.
The plaintiff does not disclose cause of action
Yes.
as well as the relief is barred under law.
It does not disclose
was
cause of
19
action, firstly, and second is that the reliefs claim. A specific, it comes under order 7 rule 11D. But kindly see my lord, page 159.
Yes.
But kindly see prayer AC.
Yes.
Decree for partition of the said shares. Again, my lord, partition of shares mentioned in schedule A2 hereof amongst the plaintiff and the defendant numbers 35 to 37 in accordance with the shares of the parties as stated in para 48 hereof. And this is what she claims, a relief that there should be a decree for partition of the shares held by the companies. Now, my lord, the partition should be effected in respect of 4 persons: the plaintiff, the defendant numbers 35, 36, and 37. Because plaintiff, defendant numbers 35 and 35 to 37 are the only heirs of late Arun Bhutoria. Plaintiff is the wife, 35 to 37 are the mother and the 2 sons. But that is the reason whether at all a suit filed for partition of shares is at all maintainable or not is the next germane issue. Kindly see, my lord, prayer BA. In 2014 SCC Online Delhi. Yes, kindly see, my lord, first in respect of this Delhi High Court judgment of 2014. Yes. Kindly see, this is 2014 SCC Online Delhi 1324. Yes, my lord, kindly see, my lord, the first paragraph, my lord. This is a specific case under Order 7, Rule 11 of the Code of Civil Procedure. My lord, kindly see right after where it is written in capitals Pradeep Nandarog. Yes, my lord, kindly see Vide order, the first paragraph. Here, my lord, the Bachev Gazda judgment has also been followed. My lord, kindly see Vide order dated August 19, 2013. An application under Order 7, Rule 11 of the Code of Civil Procedure filed by the respondent number 1 praying that the plaint be rejected was partially reflected upon by the learned judge only on the subject whether proper court fee had been affixed on the plaint by the appellant, holding that in view of the pleadings in the plaint wherein the appellant had neither pleaded actual or constructive possession of the suit properties, the appellant was required to pay ad valorem court fee, and since the appellant himself has pleaded that even as per the conservative estimate the value of the properties would be such and such 1000 crores, hearing was deferred to enable the appellant to pay requisite court fee. But I am not going into the other facts. Lordship will straight away come to para 7 of the judgment. Yes, but kindly see this paragraph 7 starts with where the issue of shareholding in a company is the bone of contention. The pleadings have to be specific with reference to what percentage of the shareholding is claimed by the plaintiff for the reason a company is distinct from its shareholders. The assets of a company belong to the company and are not the assets of the shareholder. Through the shares held, exercising control over the company, the shareholders may manage the assets of the company, but no shareholder can sue for partition of the assets of a company as can be done by a partner or joint or co-owners of a property. But this is what I am on.
Has been technically last approval has been
Well, kindly see para 7, through the shares held, comma, exercising control over the company, comma, the shareholders may manage the assets of the company, but no shareholder can sue for partition of the assets of a company as can be done by a partner or joint or co-owners of a property. So this relieves that I had indicated AC claiming partition of the shares and for distribution amongst the plaintiff and the other heirs of Arun Bhutoria is clearly barred because of para 7. Now kindly see, I'll further continue to place para 7. The plaintiff is a hodgepodge of pleadings intermixing the issue of shareholders in companies and properties held in the individual names of the parties. As was observed by the Supreme Court in the decision reported in such and such, this is what I had handed up. A company being a juristic person is the owner of the assets in its name, and a shareholder has no right over the assets of the company. He is only entitled to the dividends when declared by the company from time to time. A shareholder cannot ask a company for partition on the basis of his shareholding. But kindly marks paragraph 7, which is very important and it has impact on the reliefs claimed in the present suit. Now, my lord, apart from para 7, my lordship will kindly turn few pages of the judgment that I have handed over, and lordship will kindly take my lord para 23. Kindly see, the plaint in the instant case is a classic instance of mofussil pleadings in a corporate litigation. A claim for change of shareholding in companies has been intermingled with a claim for partition of immovable properties held by some companies and the name of some individual. The plaint overlooks the fact that a company is a distinct juristic entity vis-a-vis its shareholders and movable as to immovable properties in the name of the company belong to the company. A shareholder, again, very important, a shareholder cannot seek partition pleading that since he holds 20% shares of a company, he is entitled to a partition of the movable and immovable properties of the it should be company and to put in possession of 20% thereof. Para 23. Yes, so this was in respect of prayer AC of the ad, which is at page 159. Now, the remaining prayers that your lordship will find from page 161 onwards, all are a fallout of the principal relief of partition of shares and partition of immovable assets held by the company. Kindly see, my lord, the page 159, prayer B, prayer C, and prayer D. B, C, and D.
161.
Yes, 161. Typed prayers, not handwritten prayers. A decree for inquiry into the properties and assets of the business of the plaintiff's husband. That's B. Kindly see C. A decree directing the defendant numbers 1 and 2 to disclose true and faithful accounts of all the businesses and incomes derived therefrom. Now, a decree for such sum in favor of the plaintiff as may be found due and payable on such accounts being furnished by the defendant numbers 1 and 2. There is another issue that apart from these issues of whether a party or a shareholder is at all entitled to sue for partition of shares, whether a shareholder is at all entitled to claim relief vis-a-vis the immovable assets held by various companies, another important aspect that surfaces from the pleadings in the plaint is if she claims to be a shareholder, at the end of the day, the plaint proceeds on the basis of disputes among shareholders and management disputes. But this perhaps cannot be adjudicated by a civil court. If there are disputes between a shareholder and the management of a company, then the bar under section 430 of the Companies Act will squarely apply. I'll show judgments to even if a defense is taken to the argument that there may be disputed questions of fact and NCLT in its summary jurisdiction perhaps will not be at all entitled to go into or adjudicate the disputed questions. Even then, now the Supreme Court has said that under the Companies Act, the NCLT has been conferred with the jurisdiction to even try disputed questions of fact. If it's filed if it's filed or the proceedings are commenced on the basis of a petition filed under 241, 242 of Companies Act. But kindly see, I'll come to that aspect later on. Yes. Now, kindly see the Burlia judgment of the division bench of the Burlia judgment of the division bench of this honorable court. But this is reported at 2011 SCC Online Calcutta 1570. This is a very long judgment. Kindly gives him one. না না শুনুন এই দিলাম দিল্লি হাইকোর্টে দেখিয়েছি একদম ভালো বাচ্চা প্রিন্টটা এটা এসসিসি অনলাইন দিয়েছি subject matter of the present suit. এটা কোনো সেট আপ করে দিতে পারছি Lordship kindly takes PDF page 25 of the judgment. There is a small icon at the top of each and every page where your Lordship will find a page number. I'm so sorry, there is no handwritten page number.
25.
Yes, page 25. Right next to the SCC. Yes. Has your Lordship found page 25?
Right.
No, the paragraph before that. Which, why, yes. But kindly see. Yes, kindly see the skip first 5-6 lines. There is a last 4 lines of that paragraph, which starts with the sentence, "It is now settled."
Yes.
His Lordship has found it is now settled. The last 4-5 lines of the paragraph which starts with "once we find." Yes, it is now settled law that a shareholder of a company has as such shareholder no right over the assets of the company. In this connection, we may profitably refer to the following observations of the Supreme Court in Bachev Gazdar regarding position of a shareholder in a company with regard to the assets of the company. Now, Bachev Gazdar has been quoted. Bachev Gazdar has been again quoted. Kindly see that a shareholder acquires a right to participate in the profits of the company may readily be conceded, but it is not possible to accept the contention that the shareholder acquires any interest in the assets of the company. The use of the word assets in the passage quoted above cannot be exploited to warrant the inference that a shareholder, on investing money in the purchase of shares, becomes entitled to the assets of the company and has any share in the property of the company. A shareholder has got no interest in the property of the company, though he has undoubtedly a right to participate in the property profits if and when the company decides to divide them. The interest of a shareholder vis-a-vis the company was explained in the Sholapur Mills case, Chiranjit Lal versus Union of India, such and such. that judgment negatives the position taken up on behalf of the appellant that a shareholder has got a right in the property of the company. It is true that the shareholders of the company have the sole determining voice in administering the affairs of the company and are entitled, as provided by the Articles of Association, to declare that dividends should be distributed out of the profits of the company to the shareholders, but the interest of the shareholder, either individually or collectively, does not amount to more than a right to participate in the profits of the company. Now, next paragraph. The company is a juristic person and is distinct from the shareholders. It is the company which owns the property and not the shareholders. The dividend is the share of the profits declared by the company and is liable to be distributed amongst the shareholders. Reliance is placed on behalf of the appellant on a passage in Buckley's Companies Act in such and such, where etymological meaning of the dividend has dividendum, the total divisible sum, but in its ordinary sense it means the sum paid and received as the quotient forming the share of the divisible sum payable to the recipient. This statement does not justify the contention that the shareholders are owners of a divisible sum or that they are owners of the property of the company. Yes. Now kindly see, we therefore hold, immediately, we therefore hold that even if we assume that all the averments made in the plain to be true, it is not a fit case for grant of injunction, restraining the defendant number 6 from dealing with or encumbering its assets at the instance of the plaintiff having limited shares in the defendant number 6, and at the same time restraining the defendant number 6 from dealing with its entire share composition. Wait, my lord, may I stop here for the day, my
Maybe next day I have a matter of case today at 12.
I thought you will conclude.
I don't think that's why I came just to make that request to my lord. Like,
When do you want?
next week? No, next week. Or even
Okay, kindly keep it on Thursday, my lord, because
Thursday I'm
my
not able to.
Friday
Friday is possible.
Junior is doing very well, my lord. That is why he did not get up.
Yes, I know, I agree.
Now let Mr. Mitro submit.
Mr. Mitro came today for what? To ask for adjournment. I'm surprised.
But I've been assisting him.
Because of the supervising the entire procedure.
Supervising the procedure, my lord. Your lordship is the master of the procedure in the court.
What is junior? Whether he is junior, he is
He
supervising.
is saying the right thing or not, whether he is showing the right cases or not.
Yes, agree.
Whether he is showing the right paragraphs.
Yes.
Very well, very well. I don't need your advice, please.
I don't advise you. I won't argue. I would make some.
No. If you are so desperate to argue, I want to finish this matter before. Kindly keep it on Thursday, my lord.
Friday. Thursday I'm not here.
Friday is not a chamber.
Tuesday. Yes.
Next Tuesday I'm fine.
Next Tuesday at the top, my lord. Kindly put it a chamber application at the top.
Honored advocates of the
But may I have your lordship?
No. Question is, are you supporting the applicant or you are opposing? You are not supporting the applicant. Anyway, then you, whatever Mr. Mitro submits, you can support.
He will supplement. I'm the plaintiff.
Oh, I thought
my plaintiff wants to get my plaint dismissed.
Whether he is supporting the applicant.
He is not supporting. He is supporting the opponent.
Mr. Mitro submit.
Yes.
Yes, learned advocates for the parties are present. Learned advocate for the applicant, defendant number 1 and 2.
Yes.
Submits but could not complete the submissions. Let this matter here on 16/9/2025 under the heading Chamber Application Adjourned at the top.
And part of my lord, because it has been heard substantially.
This matter be treated as a part.
It is heard substantially.
Yes. On that score, I joined the prayer of Mr. Mitro.
The only thing is, he didn't join it Thursday. Today is Tuesday. He doesn't want it on Thursday. He wants it next Tuesday.
Yes, coming Tuesday.
Tuesday week.
And as
Tuesday
usual, he's agreed. He's
No,
always accommodating.
I'm not such a charitable and a nice person. I'm not a nice person at all.
I consider him to be a very nice person.
He may consider me to be nice, but I'm not very accommodating. But I'm opposing the prayer for a Tuesday, for next Tuesday. I want it on Thursday. But since he says he will argue, not a junior, next Tuesday, He should argue,
Of
not
course I will argue. Of course,
not supervise.
But please
of
be
course I shall
present.
be. I shall be present, my lord.
I know he's
We
a,
have many other urgent.
yes, he has, this is priority for him.
Lord's court is present.
Yes. Court is not priority, something else is priority, let it be. So I don't want to get into that. But- हाँ.
Okay, let us see on you.
Grateful, my lord. Quartet at the top, company matter.
Under the chamber application adjourn top.
at the top. I'm grateful to you, lord.
I appear for the respondent. Not pass over, my lord. Okay, pass over.
Passover is little difficult, then lordship takes it up on another day, my lord.
Okay, not today.
Grateful.
But I for the decree holder. But on the last day, Lordship had directed, actually appointed joint special officers to ascertain what balance is lying in the bank
The
accounts.
date fixed for filing the report.
Yes, my lord, we have received the report. Report has been circulated. Even the joint special officers,
Officers are not present today.
my lord, they were present. They were outside.
Passing it over.
Yes, my lord. Thank you.
No, your lordship.
But they have come. They have come. Like, কোথায়
Idea 50.
আপনি আর
I'm passing it over, okay?
Well,
I've
but
called
they
the
have,
17.
they have come.
I've called 17, yes,
Very
I'm just calling.
grateful.
কত ডেকেছেন এখন?
It's 17 and 18 are
19.
so 17,
19.
17, 19 and 32 are connected.
কল হয়েছে তাই তো? Yes, 17.
17, 9 and 19 are connected. They were appointed, the special officers were appointed in item number 19.
19.
19 special officer.
Administrator is represented.
Yes, my lord, they were represented.
What is appearing?
They will not appear, my lord. They have been. Yes, they last occasion they appeared. There were times they appear. There are times when they don't appear.
19. That
You're filing the report, lordship.
Report.
pass over this item 17. Let 19 be called. Item 18 and 19.
18 টা কত
18 and 19 টা ডেকে
18 তো অন্য মামলা ঠিক আছে অন্য
With my application. They were,
A2.
yes, with GA2. Mr. Revocation of probate, my lord.
Your lordship, if your lordship recollects, I had been arguing on the previous occasion.
You have the matter argue.
I had only commenced my arguments, your lordship. I have to finish. Your lordship, if your lordship recollects,
So you have filed your opposition to this application.
yes, your lordship, we have filed our opposition. The pleadings are complete. They have filed a reply. We have also filed a supplementary affidavit
All
of
done.
opposition.
Mr.
They have
Mitra
filed
was
a-
arguing, my lord. Mr. Mitra had completed his submission.
We'd commenced our submissions, your lordship, on the previous occasion. Your lordship, one of the first and the most important arguments that we were canvassing on the previous occasion, your lordship, was that this application for revocation of probate is hopelessly barred by the laws of limitation. Your lordship, I had
Put this on the last occasion.
yes, your lordship. I
will
will
to the merits you please argue.
yes, your lordship. I just want to finish that argument, your lordship, by placing one judgment, a three-judge bench judgment of the Honorable Supreme Court before your lordship on the limitation point. The judgment is, your lordship, 2020, volume 17, Supreme Court cases, page 284. Your Lordship comes to paragraph 12. Your Lordship, actually, I think it would be best to commence from paragraph 11.
Paragraph 11.
So, Your Lordship, the Supreme Court sets out, this is the three-judge bench of the Supreme Court, it sets out the relevant provisions dealing with revocation of probate. The relevant provisions dealing with recognition in respect of grant of probate of letters of administration in respect of the probate granted and cancellation of probate or letters of administration of the Succession Act 1925 read as follows. So 228, when a will has been proved and deposited in a court of competent jurisdiction beyond the limits of the state, whether within or beyond the limits of India, and a properly authenticated copy of the will is produced, letters of administration may be granted with a copy of such copy annexed. 263. The application has been filed under section 263. The grant of probate or letters of administration may be revoked or annulled for just cause. Just cause shall be deemed to exist where A, the proceedings to obtain the grant were defective in substance, or B, the grant was obtained fraudulently by making a false suggestion, or by concealing from the court something material to the case. Or C, the grant was obtained by means of an untrue allegation of a fact, essential in point of law to justify the grant, though such allegation was made in ignorance or inadvertently.
The applicant have been able to justify B and C or not.
That is their case on merits.
Yes. The question
Your Lordship.
You see 2 points. One is on the point of limitation. The second is whether in their petition they have been able to justify 263 B and C.
Your Lordship, I will also show that with regard to 263 B and C,
yes,
they have to plead the particulars of fraud in their application, which they have not pleaded. And I will show judgments specifically stating that under 263, if the particulars of fraud are not pleaded,
yes,
then Your Lordship, the application is liable to be rejected. So Your Lordship then comes to paragraph 12 of this judgment. I'm just finishing off the limitation point because this is a three-judge bench judgment of the Supreme Court, Your Lordship. We've shown Your Lordship a single.
I think this is taken out after 30 years.
This is taken out of after 31 years. Yes, Your Lordship.
1 year, very well. That is the point of limitation. And the other is with regard to this, even if limitation is condoned, there is sufficient cause whether 263 B and C is established or not.
Yes, Your Lordship. Limitation condemnation, my humble submission, Your Lordship, that limitation condemnation here is not possible because it's not from the date of knowledge. Their date of knowledge they claim is from August 2021.
That has to be considered.
Yes, Your Lordship.
Whether there is a sufficient cause.
Paragraph 12. The Succession Act 2025 does not prescribe a specific period of limitation for the grant of probate or for moving an application for cancellation of probate or letters of administration. The residuary entry Article 137 of the Act, which covers proceedings for which no period of limitation is stipulated in the Act, provides for a 3-year period of limitation. Article 137 reads as follows. I'm not troubling Your Lordship by reading the article per se. Then Your Lordship comes to paragraph 70. Very similar set of facts. In the present case, the letters of administration were granted in ancillary proceedings on 25th November 1994. The High Court took note of the fact that the notice of motion in the disposed of proceeding was filed on 29/3/1997. It was withdrawn on 1/4/1998. The petition for revocation of the letters of administration was filed on 29/7/1999. Proceedings were clearly time-barred. Given that the original grant of the ancillary letters took place on 25th November 1994, they constituted notice to all concerned. The day the probate was granted, Your Lordship, in the instant proceeding, that constituted notice to this applicant. So this applicant cannot come today and say that I got knowledge of the fact that in August 2021, the properties of the deceased were being distributed. And I apologize, not August 2021, April 2021. They cannot come and claim knowledge at a belated date. The law is very clear that the 3-year period commences from that date.
Limitation is well provided under the Act. That is from the date of the grant of the probate. Okay. Now the question is, if they are unable to file it within this period of 3 years, they have to show the sufficient.
Your Lordship comes to their application. If Your Lordship comes to their application, I will show Your Lordship that there is no explanation for delay. They treat the application as though it is within time.
Application definitely has to be
paragraph 20 of the application, Your Lordship.
The law from the date of the grant. Paragraph?
Paragraph 20 of the application.
Yes, paragraph 20.
Your Lordship has it, of the application. The petitioner had no knowledge whatsoever with regard to the grant. It is for the first time from the letter dated 21st April 2021, as annexed here and above, issued by the advocate of Geeta Rai and Sudipto Rai, that is us, the respondents, the heir of late Deepak Kumar Rai, that is the executor, that the petitioner came to know about the existence of the said will and the purported grant. Since being aware of the grant, the petitioner had taken immediate steps of filing the instant application seeking revocation of the grant of probate of the said will. The petitioner is 66 years of age and immediately after being aware of the grant had taken due steps of filing the instant application. So, Your Lordship, it's not as if they seek condonation of delay. They say they came to know in 2021 and that they filed in 2021. This application has no whisper of any pleadings seeking condonation of delay. There is no prayer seeking condonation of delay either. There is a mere pleading that they got to know in 2021. I am on the point that the very fact that they admit that they got to know in 2021 deals a death blow to their application, Your Lordship. Because the date of limitation began when the probate was granted. With that, Your Lordship, I think I've sufficiently addressed the limitation point. I'd shown Your Lordship the single bench judgment, which follows this three-judge bench Supreme Court, Your Lordship. Just right down. Your Lordship, this judgment follows that three-judge bench of the Supreme Court.
Okay, when you submit your written notes of arguments, give all this compilation.
Yes, Your Lordship, I'll ensure that. The mere reason I brought up this previous single bench judgment that I had cited is because, Your Lordship, this has been confirmed in appeal by a division bench of the Honorable Court. And the SLP against the division bench, the special leave petition against the division bench's judgment and order before the Supreme Court has been dismissed, Your Lordship. So, Your Lordship, this proposition of law based on the three-judge bench decision that I cited has been followed by a court, and that decision following that judgment has been upheld by a division bench of this Honorable Court. And the challenge to that division bench judgment has been rejected by the Honorable Supreme Court.
Anyway, you can give it in your compilation.
Yes, Your Lordship.
Submit.
Yes, Your Lordship. Now, Your Lordship, I come to the next point, which is the fraud point. Which is the sheet anchor of the arguments advanced. Your Lordship, with respect to this argument, Your Lordship, my humble submission is this, that whenever there is a pleading of fraud in a plaint or in an application such as the one before Your Lordship, the particulars of fraud have to be pleaded. If Your Lordship goes through the application, there are no particulars of fraud pleaded anywhere. There's just the bare pleading that fraud has been practiced upon this Honorable Court. There's just the bare pleading that the signature of this applicant, who was a legal heir of the deceased, who would have inherited the estate of the deceased, had the deceased passed away intestate, her signature, that is the applicant's signature, on the original probate application was forged. This is supposed to be the fraud. However, there are no particulars of fraud pleaded as required under Order 6, Rule 4 of the Code of Civil Procedure. Your Lordship, in this respect, the first decision that I seek to rely on, Your Lordship, is the judgment rendered in, this has not been given to you, is the judgment rendered in 2022, Volume 2, Supreme Court Cases, page 573, Electrosteel Castings Limited versus UV Asset Reconstruction Company Limited and others. The judgment of a two-judge bench of the Honorable Supreme Court, Your Lordship. If Your Lordship comes to paragraph 6.6, page 579. Lordship, my senior leading me, he's appearing virtually, he's unable to join.
Anyway, you continue for the time being.
Yes, Your Lordship. Paragraph 6.6. It is submitted that in any case, a bare review of the assertions in paragraphs 31 and 46, it can be seen that no material particulars have been pleaded so as to constitute a pleading of fraud as required under Order 6, Rule 4 of the Code of Civil Procedure 1908. It is submitted that apart from the use of adjectives such as fraudulent, etc., qua the assignment deed, no actual material particulars have been given with regard to the fraud. It is submitted that the pleadings in paragraphs 31 and 46 do not satisfy the test of fraud under Section 17 of the Contract Act 1872. Then, Your Lordship, paragraph 7.1. So I'm just placing the submissions before Your Lordship so that Your Lordship can appreciate the context. It is the case on behalf of the plaintiff appellant herein that in the plaint, there are allegations of fraud with respect to the assignment agreement dated 30 June 2018. And it is the case on behalf of the plaintiff appellant herein that assignment agreement is fraudulent inasmuch as after the full payment as per the approved resolution plan under IBC and the original corporate debtor is discharged, there shall not be any debt by the plaintiff appellant herein as a guarantor, and therefore assignment deed is fraudulent. Therefore, it is the case on behalf of the plaintiff appellant herein that the suit in which there are allegations of fraud with respect to the assignment deed shall be maintainable, and the bar under Section 34 of the SARFA-SC Act shall not be applicable. So, Your Lordship, basic case here was that whether the civil court could entertain a suit. The plea taken by the defendant was that the suit could not be maintained because it related to a property which was covered by the SARFA-SC Act. So the claim here by the plaintiff was that since I have pleaded fraud, or since I have claimed fraud, and fraud cannot be entered into by the Debts Recovery Tribunal, therefore the suit is maintainable. So in paragraph 7.2, Your Lordship, the holding of the Honorable Supreme Court is found. However, it is required to be noted that except the words used, fraud or fraudulent, there are no specific particulars pleaded with respect to the fraud. It appears that by a clever drafting and using the words fraud or fraudulent without any specific particulars with regard to the fraud, the plaintiff appellant herein intends to get out of the bar under Section 34 of the SARFA-SC Act and wants the suit to be maintainable. As per the settled proposition of law, mere mentioning and using the word fraud or fraudulent is not sufficient to satisfy the test of fraud. As per the settled propositions of law, such a pleading using the word fraud fraudulent without any material particulars would not tantamount to pleading of fraud. Your Lordship, in paragraph 8, a previous decision, paragraph 8, 8.1, previous decisions of the Honorable Supreme Court are cited. Paragraph 8.2, Your Lordship, that celebrated judgment in T. Arivindandam versus T.V. Satyapal is cited, Your Lordship. It is observed and held in paragraph 5 as under. I'm just reading from paragraph 8.2, Your Lordship. We have not the slightest hesitation in condemning the petitioner for the gross abuse of the process of the court repeatedly and unrepentantly resorted to. From the statement of facts found in the judgment of the High Court, it is perfectly plain that the suit now pending before the First Municip's Court, Bangalore, is a flagrant misuse of the mercies of the law in receiving plaints. The learned Munsif must remember that if on a meaningful, not formal reading of the plaints, it is manifestly vexatious and meritless in the sense of not disclosing a clear right to sue, he should exercise his power under Order 7, Rule 11, taking care to see that the ground mentioned therein is fulfilled. And if clever drafting has created the illusion of a cause of action, nip it in the bud at the first hearing by examining the parties certainly under Order 10 CPC. An activist judge is the answer to irresponsible lawsuits. So, Your Lordship, here, Your Lordship, the Supreme Court is stating that when particulars of fraud are not pleaded, then, Your Lordship, the plaint itself is rejectable. In this case, instead of the word plaint, we'll use the word application. Paragraph 9, Your Lordship, I'm just placing for the sake of completeness. Having considered the pleadings and averments of the suit, more particularly the use of word fraud, even considering the case on behalf of the plaintiff, we find that the allegations of fraud are made without any particulars and only with a view to get out of the bar under Section 34 of the SARFAISI Act. And by such clever drafting, the plaintiff intends to bring the suit maintainable despite the bar under Section 34 of the Act, which is not permissible at all and which cannot be approved. Even otherwise, it is required to be noted that it is the case on behalf of the plaintiff appellant here, and that in view of the approved resolution plan under IBC and thereafter the original corporate debtor being discharged, there shall not be any debt so far as the plaintiff appellant here is concerned, and therefore the assignment deed can be said to be fraudulent. Paragraph 10, the aforesaid cannot be itself. By the act itself, the assignment deed cannot be said to be fraudulent. In any case, whether there shall be legally enforceable debt so far as the plaintiff appellant here is concerned, even after the approved resolution plan against the corporate debtor, still there shall be the liability of the plaintiff and of the assignee can be said to be secured. Creditor and or whether any amount is due and payable by the plaintiff are all questions which are required to be dealt with and considered by the DRT in the proceedings initiated under the SARFAISI Act. So, Your Lordship, the Supreme Court examined the pleadings and found that the bare pleading of fraud was without justification. Here also, Your Lordship, there's a bare pleading of fraud. If Your Lordship kindly takes up the judgment in Lynette Fernandez, it has already been placed before Your Lordship. If Your Lordship comes to paragraph 13, this holding of the Supreme Court with regard to plaints in general, one finds a particular mention of it in the context of section 2, paragraph 13, Your Lordship. Coming to the second, I'm placing, Your Lordship. Coming to the second ground for just cause, regarding the allegation that the grant of probate was obtained by the appellant in a fraudulent manner, as mentioned supra, the appellant has not come forward to adduce any evidence to prove the so-called allegation of fraud. The signature of Mr. Richard P. Matthias on the will has not been challenged. The trial court as well as the High Court have recorded the finding that the genuineness of the will was not challenged by the appellant. Here also, Your Lordship, the genuineness of the will is not under challenge. Moreover, the particulars of fraud are neither pleaded nor proved by the party alleging fraud before the district court. The party alleging fraud must set forth full particulars of fraud, and the case can be decided only on the particulars laid out. There can be no departure from them. General allegations are insufficient. Merely because the appellant has made bold allegations in the revocation application that the will executed by the deceased is void because the same has been brought out by Mrs. Matthias and the same is constituted by fraud and undue influence, it will not absolve her from providing specifically the particulars of fraud and undue influence.
No, this is not a case of playing fraud upon the testator to get the will executed. The present application for revocation is fraud played upon the court to obtain an order. But
yes, Your Lordship.
This is the fraud played upon the court, not fraud played upon the testator to get the will executed.
Certainly not.
This is the facts of the case.
Certainly.
Present application.
However, Your Lordship, the law.
That is, of course, definitely they have to prove the particulars of the fraud or forgery, whatever it is.
Not just prove the particulars, they have to plead the particulars, Your Lordship.
Plead and thereafter prove, and thereafter you see whether they have been able to justify. That is the question.
Your Lordship, my contention is, Your Lordship.
Not a question, that is what? Fraud played upon the court to obtain an order.
Yes, Your Lordship.
Whether they were transparent, they have disclosed all facts or not.
I appreciate fully. The facts of the case that I'm citing before Your Lordship are slightly different from the facts here.
That is a fraud played upon the, alleged fraud played upon the testator to obtain the will executed, to obtain the will.
Yes, Your Lordship.
And this is fraud played upon the court to get an order.
Yes, Your Lordship.
Even if assuming that the testator was in a full mental capacity, sound mind and everything, and the will was executed as per the law, whether the applicant, that is the executor, played fraud upon the court to obtain. That is the question to be decided in this case. Of course, after considering whether they have pleaded and proved fraud or not.
My contention is, Your Lordship, the only mention of the word fraud that is found in the entire petition with any level of significance or with any level of stress is in paragraph 20. I've already read paragraph 20 to Your Lordship of the application. Their basic contention, for which they have shown two judgments, that there is fraud and fraud vitiates all. They have not pleaded the particulars of fraud. If they have not pleaded the particulars of fraud, they cannot lead evidence on it. If they cannot lead evidence on it and prove the existence of fraud, then Your Lordship, their application cannot succeed. has to be rejected at the threshold is my contention.
If you plead fraud, you have to prove fraud.
Absolutely. Here, the pleading is not there. No building without the plinth. Now, Your Lordship, with regard to the merits, Your Lordship, my very humble contention is that the mere production, because their contention here is that the signature was forged. They filed an application being GA number 3, seeking the appointment of a handwriting expert. The handwriting expert was appointed, although the order whereby the handwriting expert was appointed, dated 26 November 2024, is under challenge in an appeal which is pending adjudication. I'm not on that, Your Lordship. However, the point here being that the mere production of that handwriting expert's report does not by itself constitute A, proof of the contents of that report, and B, proof of the existence of a forgery. It is a mere production of the opinion. The applicant has to bring witnesses to the witness box to prove forgery. The giver of the handwriting expert's opinion, that is, the handwriting expert himself, has to be brought into the dock and has to prove his opinion. You're on that, with regard to that point, Your Lordship, I'm going to cite certain judgments, one of the Honorable Supreme Court and another of the Honorable Allahabad High Court. Actually, 2 or 3 judgments of the Supreme Court, one of the Delhi High Court and one of the Allahabad High Court, Your Lordship. Lordship gives me a moment. Your Lordship, the first judgment in this respect that I am citing, Your Lordship, is the judgment in Nalini Naveen Bhagwati and others versus Chandravadan M. Mehta, 1997, 9 Supreme Court cases, 689. This has been given to you. Paragraph 7, Your Lordship, kindly comes to. Your Lordship, I'm placing. But when the grant of probate or letters of administration is sought to be revoked, it is not clear what nomenclature should be ascribed to it and what procedure should be adopted for its disposal. Take, for instance, a situation when the suit is decreed ex parte. Order 9, Rule 13 provides for making of an application to set aside the decree on proof of certain grounds. Ex parte decree gets set aside. Similarly, when the suit was dismissed for default under Order 9, Rule 9, an application would be filed, and on proof of the circumstances for absence, the order would be set aside and the suit would get restored. Similarly, when probate or letter of administration is granted and it is sought to be revoked, Section 263 provides for the grounds on the basis of which it would be revoked. When the grounds are sought to be proved, the question is whether such an application would be treated to be a suit. We are of the considered view that an application to revoke probate or letters of administration would be treated as a miscellaneous application, may be disposed of on the fact situation in an appropriate case, either summarily or after recording evidence. The application to revoke the probate or letters of administration thus may be disposed of by the district judge, either summarily or in a given situation where it requires proof of the facts by adduction of evidence by the parties by recording such evidence as is adduced by the parties. The burden will be on the applicant to prove the facts to revoke the probate or letters of administration, and the respondent who obtained probate or letters of administration has to disprove the contentions of the applicant. In that situation, based upon the given fact situation, it will be for the court to dispose it of either summarily or after giving opportunity to both the parties to adduce evidence and consideration thereof. So, Your Lordship, my humble submission here is that here there is an allegation of forgery. Here there's an allegation that a signature of a person consenting to the grant of probate was not actually signed by her. Certain signatures which are not admitted, which appear in certain documents, were produced along with the previous application seeking appointment of the handwriting expert. In terms of the order, those documents were sent to the handwriting expert, and then the handwriting expert rendered a report. Without that report being proved, without this factum of forgery being proved, without the documents wherein it is claimed by the applicant her signatures are genuine, without those documents being proved, today this allegation of forgery in a summary manner cannot be considered. It cannot be considered on affidavits, especially if your lordship sees in my supplementary affidavit in opposition. I contend, your lordship, that the applicant who was to receive a certain amount of money under the will of the deceased received those monies under the will and accepted those monies in signed writing on a revenue stamp. So, your lordship, I have to be given the opportunity to prove that document as well. So, without a full-fledged trial, we cannot decide whether at all there should be a revocation of the probate. Because in this scenario, your lordship, the facts are such that they require proof. It cannot be disposed of summarily. Your lordship, the next judgment I seek to cite before your lordship is a judgment of the Delhi High Court, your lordship. Swarna Lata versus PP Sharma, 2006, SCC Online Del 1411, which follows this Supreme Court judgment that I placed before your lordship. Lordship gives me a moment. Your lordship, paragraph 1 itself gives your lordship the facts. The second sentence, starting with the words "the second application." Your lordship has it. The second application is filed by the respondent under section 140. Paragraph 1 itself, your lordship.
Yes. Yes.
The second application is filed by the respondent under section 114, read with, and under order 47, rule 1, read with section 151 of the Code of Civil Procedure for review and recall of the order dated 4th August 2006, praying that the petitioner's application for revocation of the will in question be disposed of on the basis of the documents on record. So, your lordship, an application is filed for disposing of the revocation proceeding summarily. How does the Honorable High Court, a single judge of the Delhi High Court, deal with this contention? Your lordship comes to paragraph 10. Paragraph 10. As regards the first ground for revocation of the will, viz., that the will is a rank forgery, no doubt it is open to the petitioner herein to prove that the will was forged by proving that the grant was obtained fraudulently by making a false suggestion or by concealing from the court something material to the case. In other words, the petitioner has to allege and prove that the letters of administration were obtained by perpetrating fraud and by concealment of material facts from the court. Thus, in my prima facie view, despite the fact that it has been held in the judgment dated 2nd March 2005 that the will is not a forged document, and the said judgment has been affirmed by the learned division bench, and a special review petition therefrom has been dismissed by the Honorable Supreme Court, it would be open to the petitioner to place before the court any material fact which was hitherto before concealed from the court to entitle the petitioner to the relief of revocation. Your lordship, this cuts both ways. This may assist them. Ultimately, after the trial, your lordship may decide that there's a forgery. But until there's a trial, your lordship, neither the facts that support them can come to light, nor can the facts that support me come to light.
So, if this petition is to be allowed, there should be a trial.
Yes, your lordship. Only then can the probate be revoked. Paragraph 11, your lordship, I'm placing for the sake of completeness. Adverting to IA number ATO filed by the respondent, learned counsel for the respondent contends on the strength of the judgment of the Honorable Supreme Court, which I just cited to your lordship previously, that the present application for revocation be not treated as a suit and be disposed of on the basis of existing documents on record. The judgment is then set out. Your lordship kindly comes to paragraph 10 then. In the last page, your lordship, the holding will be found. Your lordship is in the last page.
Para 10.
Para 12, your lordship.
12, yes.
The last page, your lordship. Wherein the judgment that I previously cited to your lordship is dealt with by the Honorable Delhi High Court. Honorable Supreme Court, your lordship has nowhere observed. The last page, the next. Oh.
Para 12.
Para 12, the last page, your lordship. The next page after that.
Yes.
Honorable Supreme Court has nowhere observed that applications for revocation of probate to be decided on the basis of documents on record, and as a matter of fact has specifically stated that it will be open for the court to dispose of the same either summarily or after giving opportunity to both the parties to adduce evidence and consideration thereof. In view of the aforesaid, the grievance of the respondent of the evidence cannot be allowed by this court, keeping in view the ratio of the judgment of the apex court in Nalini Naveen Bhagwati Supra is wholly baseless. And in paragraph 14, your lordship, the application for a documents only consideration of the matter is disposed of. So, your lordship, in the facts and circumstances of this case, as I've laid quite a bit of stress, as I've placed before your lordship, given the facts here, where there's an allegation of forgery, there's a report of a handwriting expert, there are these documents wherein it is stated the genuine signature is found, with our contention that actually in sign writing, the applicant had taken the benefits of the will due to her. In such circumstances, proof is required by witnesses being adduced, by evidence being adduced by the petitioner, with us being allowed to cross-examine, and with us adducing evidence and then them being allowed to cross-examine. So, your lordship, the next judgment that I come to, your lordship, relates to the handwriting expert's opinion, your lordship. Lordship, 2019, volume 14, Supreme Court cases, page 220. Chenadi Jalapati Reddy versus Badam Pratapa Reddy, your lordship. This judgment I'm citing, your lordship. I've given you a copy of this judgment. Your lordship comes to paragraph 10, your lordship. Paragraph 10, your lordship has it. By now, it is well settled that the court must be cautious while evaluating expert evidence, which is a weak type of evidence and not substantive in nature. It is also settled that it may not be safe to solely rely upon such evidence, and the court may seek independent and reliable corroboration in the facts of a given case. Generally, mere expert evidence as to fact is not regarded as conclusive proof of it. In this respect, reference may be made to a long line of precedents that includes, your lordship, I'm not troubling your lordship with a judgment cited by the Honorable Supreme Court. Your lordship kindly notes this is a judgment of a 3-judge bench of the Supreme Court, your lordship. Paragraph 11, I'm also placing, your lordship. We may particularly refer to the decision of the Constitutional Bench of this court in Shashi Kumar Banerjee, where it was observed that the evidence of a handwriting expert can rarely be given precedence over substantive evidence. In the said case, the court chose to disregard the testimony of the handwriting expert as to the disputed signature of the testator of a will, finding such evidence to be inconclusive. The court instead relied on the clear testimony of the two attesting witnesses, as well as the circumstances surrounding the execution of the will. Here I pause, Your Lordship. The mere production of this opinion that the signature of the applicant in the probate application was forged, the mere opinion of the handwriting expert does not mean there is a forgery. There has to be substantive evidence from their side. They have to trammel and demolish any substantive evidence from my side, showing that no, that signature is genuine. It is that substantive evidence which will take precedence, Your Lordship. Your Lordship, paragraph 13 is also important. However, Your Lordship, I'll not trouble Your Lordship by placing each and every paragraph. Paragraph 13. Paragraph 18, Your Lordship, is the only paragraph I will place for the sake of completeness. Paragraph 18. Undoubtedly, the opinion of a handwriting expert is a relevant fact under Section 45 of the Evidence Act. Under Section 47 of the Evidence Act, the opinion of any person acquainted with the handwriting of the person by whom it is supposed to be written or signed is also a relevant fact. Your Lordship, the applicant is the aunt of the respondents. She is the sister of my father, or rather my husband and my father, and the widow and the son. So, Your Lordship, I am someone who was aware of her signature due to familiar relations. My evidence is of great significance as someone who claims whether or not I am genuinely aware of the signature or not is something that will have to be decided in trial, and they will have to show in cross-examination that I was not aware of her signature. But I contend that I am aware of her signature. I contend that in signed writing, she took the benefits under the will. In such circumstances, mere production of the handwriting expert's opinion.
That question. Here the dispute is the signature of consent that is forged. Okay. Now whether the signature which she has given with regard to this acknowledgement of receiving a consideration in exchange of that will or with regard to that's a different issue. That is not in dispute here. Okay. That is not alleged to be fraud or whatever it is. That signature is not alleged to be fraud. Whatever you have disclosed now, that is her taking a benefit or consideration. That is not the subject matter of dispute. Subject matter of dispute is whether this signature is forged or not. Her signature. It is this person who is alleging that her signature is a forged one. Now that
if Your Lordship takes up the signature
yes.
in the supplementary in the annexure to the supplementary affidavit and compares it with the one that is appearing.
The question is that's a different issue. Now the court has to hold a trial. If the court thinks fit to allow the application.
Yes, Your Lordship. The court will have to hold a trial.
Not that, because that is also probably disputed, that the supplementary affidavit which you have filed. Probably she has disputed that she has not received.
Yes, Your Lordship. Our contention is that she has received it and that this is a belated application.
Now, if that is disbelief, if she says that she has not received, then that signature is also forged.
Then that is a different contention altogether. That is why a trial becomes extremely necessary.
That is also forged.
Yes, Your Lordship. So, Your Lordship, paragraph 18, 19, 21 and 23, Your Lordship. I'm not troubling Your Lordship by placing each of them because Your Lordship, as I'm given to understand, Your Lordship has come to appreciate my basic contention, which is that a trial is necessary and that the handwriting expert's opinion is not sufficient. Your Lordship, I place before Your Lordship a judgment of the Allahabad High Court, Your Lordship, rendered in the decision between Union of India and others versus Devendra Kumar Chaudhary and others. The citation is Manu UP 3550-2018. This has been given to you. Lordship gives me a moment. Paragraph 63 onwards, Your Lordship. Paragraph 62 onwards, actually, Your Lordship. So, Your Lordship, this was a disciplinary proceeding in this case, in a departmental matter, Your Lordship. And in paragraph 62, the question before the court was, the next question would be whether report of forensic expert could have been treated to be a conclusive evidence to hold the applicant respondent guilty of impersonation justifying punishment of removal. Paragraph 63, Your Lordship, is of great importance, I place. The authority of SSC to seek opinion from forensic expert in respect of handwriting and competence of forensic expert to submit its report or opinion cannot be doubted. But when aforesaid opinion or material is relied on as evidence in a disciplinary proceeding against a government servant, he is entitled to cross-examine author of the said opinion, since it is only a piece of evidence expressing opinion of such expert in a process where the government was not a party, and therefore is entitled to examine author of such opinion. Otherwise, ex parte report submitted by forensic expert cannot be valid piece of evidence to be relied upon in a departmental inquiry. The holding is in respect of a departmental inquiry, Your Lordship, but the principles are taken from a civil trial. Your Lordship, paragraph 64. When a document is relied, may be an opinion of an expert. It only means that such an expert has given such opinion. But about correctness of the opinion, unless author is allowed to be examined by person against whom such opinion has been expressed, and thereafter such person is permitted to lead his own evidence in defense to contradict the opinion of the forensic expert, it cannot be said that a valid piece of evidence has been considered in departmental inquiry. Your Lordship, then, Your Lordship, the Supreme Court's judgment is extracted, Your Lordship. Your Lordship, I'll just read the initial portion, Your Lordship. I'll not trouble Your Lordship with the entire quotation. But the application of the principle of natural justice does not imply that what is not evidence can be acted upon. On the other hand, what it means is that no materials can be relied upon to establish a contested fact, which are not spoken to by persons who are competent to speak about them and are subjected to cross-examination by the party against whom they are sought to be used. So, Your Lordship, until and unless I am permitted to subject the opinion of the handwriting expert to a cross-examination, with the opinion handwriting expert being brought into the witness box and me being able to cross-examine him, until that takes place, this opinion has no evidentiary value. It is merely evidence of the fact that an opinion has been rendered by the handwriting expert. It is not an evidence of the fact that the signature has been forged. So, Your Lordship, paragraphs 64 and 65, again, I'm not troubling Your Lordship with those paragraphs. But this is my basic contention, Your Lordship, that this handwriting expert, which is being tom-tommed by the other side to say that there is a forgery, the probate ought to be revoked. There's an entire process that has to be followed.
Anyway, so if the court decides to revoke the probate on the grounds of forgery, the court should hold a trial on this. So this is your contention.
Yes, Your Lordship.
If at all the court comes to the conclusion.
If at all the court comes to the conclusion that this application is maintainable.
The probate is to be revoked as there is forgery, then an opportunity should be granted, a trial should be held on.
Yes, Your Lordship. Final submission, Your Lordship. The last submission, last two judgments, and I will be complete. Your Lordship, is on the point that the executor was Mr. Deepak Kumar Roy.
Yes.
He had filed the probate proceeding. Mr. Deepak Kumar Roy has passed away. Now, what is sought for by the applicants, if Your Lordship sees their master's summons, they want the probate to be revoked and the matter to be treated as a contentious cause, and then for them to become defendants under Section 293 of the Indian Succession Act, and for us to become plaintiffs under the Section 293 of the Indian Succession Act, and then for a full-fledged trial to be carried out to decide whether probate should be granted to the will of the deceased Sunil Kumar Roy. Your Lordship, it is my contention.
Have you annexed in your petition, in your opposition, have you annexed that that order of grant of probate?
Your Lordship, we have.
It was a non-contentious.
It was a non-contentious cause. It was a non-contentious cause.
Attesting witnesses examined?
The attesting witnesses had signed declarations. They were not required to be examined because it wasn't a contentious cause, Your Lordship. So, Your Lordship, on this point, I say.
Apart from this applicant, was general citation issued? Any other filed any caveat? Apart from this person, this applicant, general citation and special citation were issued, but nobody filed caveat.
I am unaware, Your Lordship. I'll have to take instructions on
No,
this
it was
point.
non-contentious, definitely. There was no caveat. That is why it was made non-contentious.
As far as I'm given to understand, all the legal heirs had signed the declaration. All the natural legal heirs who would have inherited the estate had the deceased died intestate. All of them
gave
their consent. So there was no requirement for issuing either general or special
only
citation.
One of the legal heir has disputed the signature.
The only living legal heir. She has disputed her signature and brought this application after a delay of 31 years. Based on a handwriting expert's report, who has not been produced in court and who has not proved his opinion.
Yes, that's all.
So my basic contention here is this, that I cannot be made a plaintiff in this cause. Because with the death of, my contention is that a cause of action for grant of probate is an action in personam, Your Lordship. It is not inheritable by the legal heirs. So, Your Lordship, the moment the probate applicant dies, that is the executor dies.
For example, probate is revoked. If due to certain causes, probate is revoked, then no question to revive that probate case.
No question of reviving that probate case.
A separate case has to be.
Separate case has to be filed, and that is for them to pursue their remedies. Your Lordship, I am saying that this application is non-maintainable because I cannot be substituted in place of my father. So, Your Lordship, for that, Your Lordship, I'm relying on a decision of a learned single judge of the Calcutta High Court. Lordship, Hari Bhushan Datta versus Manmatha Nath Datta, reported in the Indian Law Reports, Your Lordship. The judgment of 1918 is a fairly antiquated judgment, but the points are very apposite, Your Lordship. Your Lordship, page number 865, Your Lordship. It is urged, Your Lordship, the second paragraph. It is urged on behalf of the applicant that now that the matter is a contentious cause, it is governed by the Code of Civil Procedure, and that under the provisions of Order 22, he is entitled to be substituted as plaintiff as the right to sue survives. The sole question that arises on this application is whether any right to sue has survived to the applicant. I do not think that it has. The right to a grant of administration is a personal right. And although the applicant, if the will is established, may be the proper person to obtain grant, this would be so not by virtue of any right to administration, which he inherits from his father, but by virtue of the fact that as heir of his father to the residue, he is the person most interested in the estate. The reasoning of Mr. Justice Harrington in Sarat Chandra Banerjee versus Nani Mohan Banerjee seems to be equally applicable to the present application. In that case, the executor named in the will of which probate was sought died before obtaining a grant. His widow sought to be substituted for him in the suit as being his heiress. And Mr. Justice Harrington held that as the executor right was derived under the will, the right did not survive to his widow. In the present case, the right which Hem Bhushan sought was a right from the court. And if he had obtained a grant, his title would have been derived from the court. And I cannot think devolve upon his heir. So, Your Lordship, I cannot be made a plaintiff in this cause. This cause died with my father, Your Lordship. Your Lordship, I finish with a judgment of the Bombay High Court, Your Lordship. Thriti Sam Shroff versus Shiraz Bayramji Ankalesarya. 2007, Volume 4, Maharashtra Law Journal, page 56, Your Lordship. Been supplied to you. Lordship, gives me a moment. Lordship. Paragraph 2 are the facts, Your Lordship. I'm not troubling Your Lordship. Basic facts being that in the civil suit, the plaintiffs have died and it is not in dispute that the original petition was filed by them for probate of the will of the deceased in their capacity as executors as named in the will. The suit abates and therefore, obviously, the notice of motion in the suit, which does not remain pending for interim orders, cannot be entertained. The question therein, very simply, was whether the death of the plaintiffs who were the executors of the will led to the death of the proceeding, or whether the heirs of the plaintiffs, the executors of the will, could be substituted in the place of the deceased plaintiffs. Your Lordship, following the previously cited judgment of the Calcutta High Court, Your Lordship, in paragraph 24, Your Lordship, it was held by the Bombay High Court. In Haribhusan Datta versus Manmatha Nath Datta and others, the judgment that I cited to Your Lordship, a residuary legacy under a will, a legatee under a will, had applied for grant of probate of grant of letters of administration to the estate of the testator with a copy of the will annexed. However, during the pendency of the application, he died, leaving his son as his heir and legal representative. The latter applied to be substituted in the place of his deceased father and to be granted letters of administration with a copy of the will annex. It was held that a right of legatee to obtain a grant was a personal right and it does not devolve on his heir.
At that point of time, you see, 1919, this Indian Succession Act was not in existence. Probably there was some other law that is in 1919.
Yes, Your Lordship.
This act came 1925. Whatever is there under the act, that has to be followed.
Yes, Your Lordship. Your Lordship comes to paragraph 30, Your Lordship, where the holding under the act is provided. Because the principles are applicable. Paragraph 30. Considering all the above decisions, it is abundantly clear that the probate proceeding, though on being contested, becomes a contentious proceeding and therefore it is to be proceeded in the form of a civil suit. But that by itself does not transform the proceeding into a suit under the Code of Civil Procedure. The provisions of the Code of Civil Procedure would apply to such proceedings to the extent they are not inconsistent with the provisions of the law comprised under the said Act. Section 226 of the said Act specifically provides that in the case of the death of an executor, representation would survive to the surviving executor or executors, as the case may be. At the same time, Section 222 clearly specifies that the probate can be granted only to an executor. In other words, the probate proceedings are essentially at the instance of the executors, so named in the will, and can survive till the executors survive. Moment the sole executor dies or all the executors die, the question of proceeding being kept alive does not arise at all, as there would be no occasion in such a case to grant any probate. Such a proceeding would die a natural death as a consequence of non-survival of any executor. In such circumstances, the question of applicability of Order 22 or the Code of Civil Procedure does not arise at all, Your Lordship. Paragraph 32, Your Lordship. Once it is clear that the proceeding does not survive on the death of last surviving executor, such proceeding is bound to abate. So, Your Lordship, the proceeding itself has abated. So, for the mother probate proceeding to be converted into a contentious cause, that is not possible, Your Lordship. That is my humble submission. That is why this application for revocation is ipso facto non-maintainable. Because the relief it seeks cannot be granted. Because it seeks reliefs in respect of a dead suit.
That's a different issue. After the grant of probate, whether the probate can be revoked or not, the section is clear. Okay, if they have justified, the law will take its own course. Now,
Yes,
thereafter, the second phase, if it is revoked, whatever is provided under the law will follow its own course.
Your Lordship, kindly sees their master summons, their prayers, Your Lordship. Because their prayer isn't revoke the probate merely. Their prayer is that relegate me back to trial. Your Lordship sees their master summons.
It is, that is there. Whatever is there, you see. Whatever is there in the law, that has to be followed.
Yes, Your Lordship.
Yes, that's all.
That is all, Your Lordship.
Yes, learned advocates for the opposite party conclude the submission. let this matter appear on
Next Thursday.
coming Thursday.
Coming Thursday.
Yes, let this matter appear on 11/9/2025 for reply by the applicant. So after the reply, you can deal with this, and when you file your written notes, you can file with the compilation, or if you have some additional set, when you file your written notes of arguments list of dates, you can file these judgments with that particular compilation also.
Your Lordship, let these be there. We will have separate copies prepared and
File a
bound
separate
and then.
compilation,
Yes, Your Lordship. Paginated properly.
because after
For
they
ease.
conclude, we have to file your written notes of argument.
Yes, Your Lordship.
Yes, I've kept it on 11/9 for reply.
Grateful, Your Lordship.
Matter number 70, 90, and 32.
I appear for the decree holder.
My lord, I appear for the judgment letter, my
The
lord.
special officers were supposed to file a report. We have been served.
Report of the special officer.
Yes, sir.
Yes.
Report is circulated.
Yes, my lord. I have. Not, not in the report. Highlight him. Highlight him. Oh, acha, I found.
My lord. My lord, in the previous matter, my lord, can it be kept on 18th, my lord? Next Thursday, my lord. There's some difficulty on the 11th, my lord.
I shall consider on that day. If you are unable to come,
No, my lord, it's Mr. Mithru will give a reply, my lord. Kindly keeps it on next Thursday. That is a.
the other side
Other
is
side is here. Is there?
okay. Instead of 11th, I'm keeping it on. That is on 6. Shall I keep it on 16th?
No, my lord. Next Thursday.
Okay, 18th.
18th.
ওই 11 জায়গায় ওটাকে 18 করে দিন।
So grateful, my lord. Sorry.
If your lordship sees the report, my lord, here, my lord, the current account balances which are lying, my lord, in the bank accounts which I had provided, those have been furnished. My lord, these have a mere thousands of rupees, not even lakhs. কিছু কি বলেছি আমি সেটা নিয়ে অবগত। But my lord, in that light, my lord, I would pray certain orders, my lord, today. One is, my lord, whatever balance is lying in these bank accounts as on this date.
ICICI Bank, it is crore.
No, my lord. Yes. No, not crore. This is credit. None of them are in crores. It's all credits. Karur Vysya Bank, 5,000 something. HDFC Bank, 23,000 something. Then Lordship sees my third one. Union Bank has 8,000 something. RBL Bank has 2 rupees. HDFC Bank has 0. RBL Bank 0. Karur Vysya Bank 1,000. ICICI Bank 600. DCB Bank, they say that it has been frozen by the orders of this court. They could have furnished the balance. Frozen, unfrozen would not be very relevant insofar as furnishing of balance is concerned. Lordship has already desired, but they were supposed to. But what has happened here is that the special officers were directed.
DCB, no. If there is an order of the court, freeze part of the order of the court.
Yes, frozen.
When that order is modified, you
They were only supposed to furnish the balance, whatever is there. There's only that much.
And my
My
lord,
lord,
upon instruction, I'm submitting before your lordship. If the bank account is frozen, then neither the bank will show any balance nor the bank will furnish any details because
there
it's
is an order of the
frozen
court.
under the order of this honorable court.
Lordship has passed an order. And this, my lord, the bank has not furnished these information. It is the judgment debtor who has furnished this information. Lordship's last direction was the special officers were supposed to ascertain whatever sums are lying in these bank accounts.
So further clarification is required for DCB
this
Bank.
account, if your lordship desires, then my lord will kindly direct the bank because I need to show this order to the bank.
But we shall communicate it to the bank. All Lordship may direct the special officers.
Learned advocate for the parties are present. Learned special officers are also present, and they have submitted the report. Let the report file be kept with the record. It appears from the said report that the balance lying in Karur Vysya Bank, KARUR Bank Limited, furnished along with the balance lying in HDFC Bank Limited, Union Bank of India, RBL Bank, HDFC Bank, RBL Bank, Karur Vysya Bank Limited, ICICI Bank Limited. Stop. However, with DCB Bank, the report of the special officer states that DCB bank account is already freezed by the order passed by this court. Stop. The learned special officers shall ascertain from the bank authorities the date of the order and the amount lying in the said bank. Now, upon obtaining such information, the learned special officers shall submit a report on or before 23. Yes, 23.
No, not after. No, my lord, I'm praying, my lord, before vacation. My lord,
23/9.
yes.
2 weeks you are getting. 23/9/2025. Let this matter appear on 23/9/2025 for report of the special officers. Learned special officers are entitled to a further remuneration of 100 GMs each.
But insofar as the other bank accounts are concerned, the balance have been furnished. But these balance can be transferred to us. The Lordship may issue necessary directions to the bank.
Judgment debtors are restrained from operating bank
1,000.
account Karur Vaishya Bank Limited, HDFC Bank Limited, Union Bank of India, RBL Bank, HDFC Bank Limited, RBL Bank. We have mentioned twice. Oh, there are two accounts.
Two accounts.
Two accounts of RBL Bank in two accounts. Karur Vaishya Bank two accounts.
Yes. RBL Bank has 0.
ICICI Bank Limited. These accounts will not be operated without the leave of this court.
And one of the funds lying in these bank accounts may be transferred to me.
On the next day, I shall consider
But
they will not operate.
there are hundreds, few hundreds. What will they operate?
Let them not operate this bank account. On the next day, I shall pass that order.
Very well. Malad, now, Malad, I'll make two more prayers here. Malad, they have furnished whatever bank accounts that I could ascertain. I had given the details, and those bank accounts details have been furnished. Now, Malad, my application also has another prayer that whatever bank accounts are linked to the judgment debtor's PAN, permanent account number, and the other company in which the judgment debtor holds 99% shares, that PAN. Now, that has not been furnished yet. Now, the judgment debtor may choose not to furnish them, but I have made a prayer for direction upon the income tax authorities so that they could furnish whatever bank accounts are lying connected to these PAN cards so that all the assets of the judgment debtor may be ascertained. Otherwise,
let us wait till the next day. Let us ascertain this bank account. Okay.
This bank account, Malad, will not have anything. Malad, this has been.
This bank account has certain amount. Okay. If they are restrained. Okay.
Malad, they have been restrained from day one of the execution. Malad, this has been since.
If my learned friend is trying to drag the company, then he cannot, because the company is no one in the proceedings.
Very well. Then only the bank accounts of the judgment debtor.
You are for?
I am for the judgment debtor, my lord.
Judgment debtor, that is okay.
It's an individual.
If the company is agreed, let the company come and say that.
Yes. But this has been going. The Lordship has seen. The execution is of 2016. The decree was of 2014. But even the principle has not been satisfied.
Just keeping it after 2 weeks.
But on the next day, I am putting my learned friends on notice. I'll pray for these orders. Let them not take any adjournment on that day.
Yes,
They have been taking adjournments for the last 6 years.
That should take us to the DCB bank.
Okay, the learned advocates for the parties shall extend necessary cooperation to the special officers.
Next week, next. Take it. Great.
I appear for the 31 of the 31. 31.
17, 19. So back to the
Here in item 25, which is my discharge application. I appear for the plaintiff in the testamentary suit. Lordship has to take up the substitution application first today, which is item 31 of today's list. Item 31 is GA18. Two of the parties to the present proceeding have passed away.
G18.
G18. Will kindly take that up because that's the substitution and amendment application. Paragraph 100%. Paragraph 17 and 18 of the affidavit in support of master summons if not okay. Yes. Only for
Date
substitute.
of defendant number 4 and defendant number 6.
Read it.
And the representatives of defendant number 4 mentioned in paragraph number 19.
Defendant number 6 on abstract right? Defendant number 4. Defendant number 6 and 4. The 1, 4 and 6. Right. There will be recording date. Recording date and or
But defendant number 4 is concerned, it is stated in paragraph 19.
yes, my lord.
And defendant number 6.
70. Paragraph 70. 1 7. It's opposite. That's my lord. Another part. We've come to know in July 2025 when my learned senior friend advocate on record wrote to us informing of the death of his client. Paragraph 70 and 70. Oppositionটা কে ফাইল করেছে? 70. 90.
Right.
Position of 6. Carried through constituted return. So, respondent kindly substitute these two.
Yes, record an order.
Not a
Yes. I was appearing, my lord, for defend respondent number 6. Now, my lord, respondent number 6, my lord, your lordship will find has been pleaded as Ashok Kumar Chawla, one of the directors of Messrs. DP Amusement Park Limited.
Yes.
Now, my lord, in paragraph 16,
Yes.
my learned friends have said that pursuant to the order dated 19 May 2011, passed in GA 2014 of 2010 and GA 3769, both in PA 15, to a caveat was lodged on behalf of the aforesaid DP Amusement Park Limited by Ashok Kumar Chawla as director of the company. This is correct. The reason why I say so, my lord, the order of 19th is not there, but my lord, I have a copy.
আপনি কি বলছেন কোম্পানি ইনস্টেড অফ ডিরেক্টর কোনো অসুবিধা
My lord, if your lordship sees the first line of that order, first line,
দিতে পাবে অপোজিশনের অ্যানেক্সের দিতে আছে
so my lord, it's the applicant company who is the actual caveator, who is being represented by Ashok Kumar Chawla. So my lord, what?
Not Ashok Kumar Chawla.
Yes, but the order either way, my lord. So therefore, my lord, instead of my lord substituting the
You
director,
are representing whom?
I represent the company.
Company is not brought into the record.
Yes, so company should be brought into the record.
That leave has to be granted to him.
Yes.
Learned advocates for the parties are present. This is an application for substitution for recording the death of defendant number 4 and 6 of the present proceedings. It's contended by the applicant that the defendant number 4 is died on 2/5/2025. Defendant number 6 died on 4th May 2025. Hearing the learned advocates
লিভ দেবে বলে দিল তো
that this application
পছন্দ হচ্ছে না
could be allowed.
এস্টিমেটের ইস্যুটা কোম্পানি
Thus, I allow
জজ তো অ্যালাউ করেছে তাই
that application.
অর্ডারে তো তাই আছে
Let there be an order in terms of pair A, B, C, D, E, F,
এরপরে দেখ কি হয়
and G of the master summons dated
আরে এবার আমাকে চিঠি দিয়ে পাঠিয়েছে
30th July 2025. The amendment be carried out within a period of 1 week after vacation.
No, my lord, before vacation we'll carry it out. My lord, we grant us
Period of, let the amendment be carried out within, there is only 2 weeks left, 2 weeks.
We'll carry it out within that time.
No, the
Within 2
amendment be
weeks.
carried out within 2 weeks and the re-verification be made within 1 week after vacation.
Well,
It is submitted by Mr. Dotto that the
Leave to intervene was given to the company.
the defendant number 6 ought to have been the company.
To intervene.
Company. Defendant number?
Defendant
Number
number six,
six.
this amendment to the cause title after leave was granted is carried out by the department because this is a testamentary proceeding.
Okay.
It is the director who has been specifically implicated.
Okay. No, as per the order of the court.
Yes,
It is the
department has done this. We have not implicated. So let this
Learned
stand
Mr.
as
Dotto, learned counsel submits that the defendant number 6 ought to be reflected as MSDP Amusement Park Limited, who are the intervener.
Yes.
that's already there, my lord. It says the cause title, my lord, has the cause title. It says Ashok Kumar Chayala, director of DP Amusement. That's already there. Now, this was done since this is a testamentary proceeding. The department has specified the name of the director as well, and that is why my learned senior friends, advocate and record, also wrote to us informing of the death of the director and sought his substitution.
Okay,
my lord,
but
whether the amendment-
as as it is contended, the said director died.
Yes.
The director died.
Director died
Okay, let steps be taken for necessary amendments
of the company because the leave was given to the
by
company.
bringing the
The-
necessary party on the record.
So that necessary party, look, otherwise what is happening is today I am the director. Tomorrow somebody maybe else be the director. But the Millet, that's what I'm showing. Kindly see the company.
Capacity, not in individual capacity.
No, no.
That's how he's been impleted as well.
GA 20 is an application. Kindly see the first line of that order. Joseph ke din to.
No, because you see the company wants to intervene. He is not acting for in his personal capacity.
Yes, no, I'm not.
Department will not allow a candidate in a
Your Lordship passes an order to that effect.
without there being a natural person who is seeking to be a caveator.
Okay,
My lord, it was-
because this director that take necessary steps for
that's
bringing
already there.
the.
My lord has allowed
So,
that.
My lord, leave for intervention is already there.
Yes.
My lord, that leave is already recorded in the order. My lord, formal
Therefore,
implement of a company in a testamentary suit is not required.
Why not? It's not required is one thing. But the question is that the leave that is granted was granted to the company to intervene.
To intervene, not to
So,
be
Millard-
impleted as a party in the proceeding.
Millard, that leave is there on record, Millard, and
Director remain as a party.
and the company can also be.
However, the leave which is granted to the respective company to intervene remains.
Yes.
My lord.
Grateful, my lord.
It means
My lord, so far as the other applications, these are for discharge of caveats.
The other applications will be taken up for the next day. So for this application is concerned, it is disposed. Let the other applications be taken up.
My lord, amendment of the main, my lord, proceeding will have no bearing on the discharge application. So, my lord, any day next week, lordship fixes these applications, my lord.
Discharge is something else.
I am saying, my lord, I lodged a caveat, I am withdrawing the caveat, I don't want to contest. My lord, this can be decided independently.
We are still on the first, Millard. Millard, your Lordship's desire was that application, so there is no application, Millard, that application has been disposed of by the order of 90.
No, I have filed a separate application, which is there in the list today.
Save and accept other applications. The other applications are not today.
Very well.
This one.
Very well. Grateful.
Your Lordship,
I'm just making it not today. I am only.
no, I'm not on that, Millard. Your Lordship had asked the dependent numbers, the director's name to be substituted. I am saying.
And the company which was granted permission to intervene, that leave continues.
Yes.
So therefore, he must be a party to it. Otherwise, Millard, I won't be served.
Planning is one thing and party is
Yes.
one thing. This is a procedural matter. The natural persons are made party. Okay.
Then Millard, kindly clarify
No, I
that.
have clarified that the director who has died, let necessary amendment be carried out.
And that is the application which lordship has allowed.
As the other leave which was already granted to the company to intervene, that remains.
But there was only one leave granted. Kindly see, Millard, the first line of the Lordship's, your Lordship. Kindly see there's only one leave granted. Kindly see.
It's better let him take steps to bring the other director on the record.
Very good. Let him bring. All I'm saying is that it is Ashok Chawla representing DP Enterprise. It should be DP Enterprise represented by such and such company.
My lord, let a proper application be taken out by a person who wants to be impleted in a testamentary suit, my lord. My lord, leave to intervene is something else. My lord, leave to be impleted is something else.
I'm not asking for.
But he will continue to
Pursuant to the leave which is already there in the record. That lordship has already provided.
The problem which is happening here is this, Millard. What they are doing, the company has a registered office which is separate from its directors. Now, Millard, in this petition only this has happened and I had to apply for recalling, which was recalled. They serve the director. They don't serve the company. On the premise that we have served the director. Now, my lord, it's the company who is interested. Then let them at least serve the
Okay, let
company.
us see on the next day. Let them take steps with regard.
My lord, so far as the other applications are concerned, it will come up on 11th. Grateful, my lord.
This matter, my lord,
Opposition side করেছিল।
matter 24, no?
Yes, Your Lordship.
24. The next matter.
Yes.
The matter's identical issue is before the division bench in the same suit. But they want substitution. I'm saying suit has abated. I have lost before the learned judge and Millard filed an appeal matters before the division bench. In the meantime, another substitution has become required. My learned friend has filed this application.
So let us consider on the next day.
Yes,
11th.
Your Lordship, similar issue is not pending before the division bench. My lord, no, not on the point of substitution, Your Lordship.
Yes.
No.
It arose out of
But
a
I gave
substitution.
No. It arose out of
Item-
an application for
item
extension.
22.
24, Your Lordship.
Oh, you're right. You're right.
We are for item number 22.
Millard,
24. My lord, 24, sir, was
24.
uh,
I'm sorry, Millard.
it's not 20.
So your matter is 22.
No,
24, Your Lordship, sir. It's not.
22 appears.
No.
Millard, would your lordship, Millard, take it up on the 23rd, which is the next
My lord,
Tuesday? I am not
Item-
there on
item-
16th and
Item
18th.
number 22.
24, Your Lordship.
Yeah, item number 22.
My lord, only one thing, my lord, let me point out, my lord, 4 or 5 dates, my lord, have gone by. My lord, even on the last occasion, the matter was heard and time was sought for, my lord.
Let this matter appear on
No, 23rd, Millard.
23rd. So on the verge of the closure. You see,
Millard, then Tuesdays and Thursdays, I am not there for the next
My
3
lord,
days.
maybe if
But-
only any other date.
Yes.
Yes.
I am not there on the 18th, Millard.
Okay,
Next
let
Tuesday.
this matter appear on 23/9/2025 under the heading chamber application adjourned at the top.
I'm grateful, Millard.
My lord, 22, my lord.
22, yes, whose application GA1?
My lord, application, my lord, was for substituted service, my lord. My lord, I've complied with the order, my lord, of your lordship, my lord. My lord, the affidavit of service, my lord, is to be taken on record.
I'll take it up on Thursday.
My lord,
Well,
can
just the-
item now 28, my lord, can you take it up on Thursday, next Thursday?
I'll take
My
it
lord,
up.
the other side is there.
My lord, by time,
My lord, next week.
I'll take it up on Thursday. Other matters, I'll take it
Milord,
up on
ask
Thursday.
Milord, 28, Milord.
Yes.
Milord, my
Next
learned
week.
friend is asking for Tuesday, next Tuesday, Milord. Other Mr. Rupak Ghosh is suffering from
Some difficulties,
Okay, I
that's
shall
why.
consider on Thursday, okay? Let it remain in the list. I shall consider on Thursday.
Yes.
আর ফর অর্ডার যে একটা দেখে না টু বি মেনশন আর যেটা ফর অর্ডার আছে ব্যাস
My lord, I am appearing for the plaintiff number 1. This is regarding the amendment. What happened, my lord? Paragraph number 204 and 5 has been inserted, added to the plain that has not been marked. I am praying leave to mark it with red ink, my lord. While complying with your lordship's order for amendment, it has been detected, my lord.
So, as per the order, as per the report, it appears that paragraph number 2 capital N in the proposed amended plaint annexed with the petition so and so marked as annexure B is not tallying with paragraph number 2N of the original plaint. Anyway, I'm making it not today. You go through the report, okay? Thereafter, necessary orders can be passed.
So I have got the.
You consider the report. I will take it up tomorrow. রিপোর্টটা দেখান রিপোর্টটা দেখান হ্যাঁ এই তলায় কি আছে দেখি তলায় ও ইয়েস 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 নট টুডে জাস্ট
আমি কি চারটে পরে আসি?
আমাদের নাকি ও সরি
My lord, I am appealing for the applicant in this matter, my lord. My lord, on 30th of July, my lord was pleased to appoint a special officer for executing the deed of conveyance. My lord, this is the Everest House building matter.
yes yes yes
My lord, the special officer is yet to execute the deed of conveyance, my lord. Humbly seeking
that is
for
not
an
yet executed
My lord, he is yet to be executed by the special officer.
No, I have to special officer. They did nothing, madam. Not a paid remuneration even and no tax table.
no actually the order was passed on 30th July okay and date was fixed on 3/9/2025
My lord.
for report.
My lord, kindly keeps it any time after the vacation, my lord. Meanwhile, necessary steps will be taken, my lord.
Remuneration will be fast.
My lord, that will be done, my
Yes,
lord.
record an order. Learned advocate for the applicant and learned special officer are present.
Your Lordship, I'm also appearing on
Yes,
behalf of the
learned
respondent
advocate
number
for
10.
the applicant, learned advocate for
Respondent number 10, the Owners Association.
okay, defendant number 10 and learned special officer are present. As the execution of cell deed could not be completed, time is extended to complete the same on or before 29/10/2025. Let this
Obliged.
matter appear on 29/10/2025.
Obliged, my
In the remuneration director.
Yes.
Remuneration not paid.
Oh, remuneration. Yeah, you have not paid the remuneration.
My lord, need not record. I'll take instruction. Will instruct my
Sir,
client.
please pay the remuneration.
Obliged, my
Pay the remuneration. The special officer will conclude do his part.
my lord.
Okay, not today.
Lordship, I appear for the plaintiffs. Lordship, on the last occasion, Lordship had directed had given me leave to file a supplementary affidavit to the clarificatory report filed by the valuer. This is a partition suit, Your Lordship, where valuer was appointed. He filed a report and thereafter a clarificatory report was also filed. So we wanted an exception to that valuer's report and we also wanted to file a supplementary affidavit to the clarificatory
Have you
report.
filed that?
Yes, Your Lordship, I have served them. I just want to file it.
Yes, record an order.
I
Lordship,
am appearing for defendant number 1 and 2, my lord.
Learned advocate for the plaintiff and learned advocate for defendant number 1 and 2 are present. The supplementary affidavit filed with regard to the exception of the special officer's valuer's report is
Lordship, clarificatory report.
no supplementary
The
affidavit
affidavit
to
to
the
the
clarificatory report of the valuer which is filed today be kept with the record and a copy be served. Let this matter appear for further orders on 17/9/2025.
17th 9. Well, your lordship, will kindly be fixed the time, my lord, because
No, in the usual course, it will be taken up.
Lordship, I've already served copies of the.
Okay. Matter in this matter, my lord. Year 22 is disposed.
Yes, my lord. There was an order for transposition, but due to the unavoidable circumstances, as the learned advocate and record, Mr. Bikash Boishu, was seriously ill and he was admitted in the hospital in Hyderabad.
So transposition is yet to be done.
Yes, my lord. The 1 week time may be extended, lordship.
Yes, record an order. Learned advocate for the you are for the
Defendant number 1A and 1B. Now,
defendant number 1A and 1B is
in whose
present.
favor the order for transposition has
As
been
the
made.
transposition order passed on
My lord, 7th August 2025.
7th August 2025 is yet not implemented. The time to implement the same stands extended till 23/9/2025. Let this matter appear on 23/9/2025 under the same heading.
I'm great.
My lord, I'm appearing on behalf of the plaintiff lordship. Now, on the last occasion, I had taken a point that in 38, the matter ought to be.
So, yes.
The matter
Okay.
should be.
So let this matter appear on Friday.
Friday.
Yes. Yes, record an order. Item 38. Let this matter appear on.
Will it be my lord's pleasure to fix a time?
Yes, yes. Let this matter appear on 12/9/2025 within first 5 matters.
It's my duty to mention that I have received one proposal of settlement from the plaintiff.
Okay. That
We
you
shall,
consider.
we shall look into it on the next.
Yes. 39, yes.
Actually, I beg to appear on behalf of the added defendants. I'm praying for a short passover. My senior is on
Okay,
his
not
way.
today then.
Not.
My lord, I'm appearing for the plaintiff respondent in this matter by the order dated 2nd of August. Your lordship had allowed the
Yes.
defendant's application and had directed the ROC to file their report, interim report, my lord.
Yes. Whether the report is filed.
My lord, I don't think my other side is appearing today.
Okay, then let it be not today.
Grateful, my lord.
This is my application, my lord.
Your application.
I'm asking for my lord.
Your application.
My application was allowed by your lordship.
Oh, sorry.
My application was allowed by your lordship, my lord, by the last order dated 14th of August 2025.
Yes.
Now, my lord, I am seeking only two innocuous, my lord, corrections that, my lord, had been missed out by us from indicating to your lordship, my lord. One is a typographical mistake in the order made by the last page of the order, last line of the order, my lord. This date, master summons was dated 28th of day. But while
you consider the report of this register original site, let it appear tomorrow. Okay.
But this is not 28th of.
No. There is a report with regard to this earlier order. You just consider let it appear tomorrow.
Or my lordship can pass it over for a while. I can just check
Just not today. Okay. Come tomorrow.
Item number 41 minute.
41.
Master report দিয়েছে
This matter, I am of the defendant, my lord. I have take out an application, my lord, for
GA5.
GA5, my lord. My lord, I have taken out an application, my lord, for directing the plaintiff, my lord, to give inspection of the document. Earlier, there was an order for inspection, but
Okay. Where is the plaintiff?
the plaintiff is on the earlier occasion. He didn't appear.
Acha, item 42. Let this matter appear. Let this matter appear as new motion on 15/9/2025.
15/9.
Your lordship, I appear for the defendant in this matter.
The plaintiffs have filed an application for
Yes, yes, yes. The hearing was concluded.
Yes, Your Lordship.
This application is allowed. With regard to the point of law raised regarding stamp duty, it is kept open to be argued. And the commissioner is appointed, who shall take the deposition and submit a report on or before 27/10/2025. 27/10/2025 for report of the learned commissioner.
27/10.
10.
Your Lordship will, they'll make appropriate submissions, Your Lordship, because the vacation is there.
Whatever it is, time is there.
Yes, Your Lordship. So far, Your Lordship has recorded that the question of
That
stamp
will be
duty-
considered at the appropriate stage.
duty has been paid.
Yes,
they
yes,
have
yes. I've recorded that.
registered.
Yes. Those points will be considered at the appropriate stage.
Grateful.
Call the fixed matter.
There's only one difficulty, only since your lordship has another list at 3 o'clock. There's a matter fixed at 3, so I will have.
So you can argue up to 3?
Yes, yes. Now, your lordship will remember that I had met out on the last occasion shown to your lordship the written statements, one filed by Marshall House, the other by Mahabir Properties. And very significantly, it was not mentioned in either of the written statements that a multi-storied building had been constructed. And there were subleases and assignments made in respect of diverse spaces in the multi-storied building in favor of almost 800 persons. That was the complete suppression. Well, I showed your lordship as to how argued before your lordship that this suppression is a suppression of a material fact and would amount to fraud on court also. Now, it is proceeding on this basis that the decree in the suit was obtained. I specifically used the expression that the decree was obtained because, had proper, facts been disclosed to court, this decree would not have been filed. Now, before considering the decree, please once again have a look at.
Your is GA16,
GA44.
GA44.
I had shown your lordship there are two written statements filed, one by Marshall and Sons, the other by Mahabir Properties.
Yes.
And I had shown to your lordship that the written statements filed did not disclose the fact that
the lessee, the other is a sub-lessee.
Yes, but neither of them disclosed the fact that since the year 1980, there was a multi-storied building standing in the property, completely occupied, in respect of which the defendant number 3 had, or rather Mahabir Properties had, pursuant to the right of assignment granted to it, it created assignments in favor of diverse persons. Now, the question is, kindly pause here to just reflect on this once. What would be then, the impact of this suppression on court? Is the court not entitled to know, while considering a suit for eviction, as to who are the persons in actual possession of the property, and as to in what character or under what circumstances they came to occupy the property? Here, one of the questions that your lordships have repeatedly considered in this regard is whether the occupant is in settled possession or in fugitive possession. Now, here, they are all in settled possession because they came to occupy the property pursuant to express rights granted by the parent deed of lease, true sublet and assign, and thereafter under the sublease, which also gave similar rights. Now, this is the suppression. Now, if your lordship comes on to the decree, which I have not yet shown to your lordship, please once again have a look at the prayers in the plaint, The plaint starts at volume 16, page 2244. The prayers are at 2257. Your lordship will remember, I'll just, for the time being concerned myself with prayer A. For khas possession of the suit premises fully described in schedule being annexed A. 2257.
Yes.
And your lordship will remember that the ground was that 8,000 square feet in the roof out of, my lord, a building, my lord, which is covering 1,60,000 square feet, has been, my lord, constructed without sanction. Now, my lord, importantly, my lord, the Kolkata Municipal Corporation is not made a party. No complaint is made to the municipal authorities that, my lord, there is a structure which has been erected without, my lord, permission or appropriate sanction. And yet, my lord, this is the relief that is sought. Now, in considering this, please, my lord, see as to how the decree proceeds. My lord, that your lordship will find at volume 16, page 2315. Now, by this time, my lord, there are two defendants.
16?
2315.
Yes.
Now, my lord, I will not trouble your lordship with the initial, my lord, paragraph. Please come to 2316. Now, my lord, please see how it, my lord, proceeds at 2316. By a registered deed of lease dated 20th April 1964. By a registered deed of lease dated 20th April 1964, the first defendant, that is, my lord, Marshall and Sons, was inducted as lessor of the entirety of the suit premises. It should be, my lord, lessee, Marshall and Sons, entirety of the suit premises by Morari Chanlaw since deceased on the terms and conditions stated therein. According to the plaintiffs, the first defendant took possession of the suit premises and is in possession thereof. Now, my lord, please, my lord, underline this portion. Took possession, first defendant took possession and is in possession. Who is the first defendant? Marshall and Sons. Marshall and Sons had, by a registered deed of lease, transferred this, my lord, tenancy, this lease, or assigned this lease to, my lord, Mahabir Properties, who had thereafter, my lord, assigned it in favor of 800 odd occupants. But, my lord, here very important is, my lord, here.
Was it admitted in the written statement that they are in possession?
Yes.
It is the.
Yes, my lord, because it's a collusive written statement.
Written statement that they are in possession.
That's right. Now, my lord, this is what the court proceeds on. My lord, kindly see. Decree obtained by fraud. I'll come to 115 later of the Transfer of Property Act. According to the plaintiffs, and this is what the court proceeds on. The first defendant took possession of the suit premises and is in possession. So, according to the plaintiff, Marshall and Sons in possession. After settlement of the right title and interest in respect of the suit premises by Murari Charan Law since deceased in favor of the plaintiffs, first defendant attorned the tenancy. The plaintiffs, after attornment, granted rent receipts in favor of first defendant. One of the Shebites of the plaintiff, by a letter dated December 4, 1987, requested inspection of the suit premises, which was refused. Now, my lord, please see, my lord, now, my lord, the gap is there is no mention of how, my lord, the property thereafter was transferred or the rights under the original lease were transferred. Straight away, we come to what? One of the Shebites of the plaintiff, by a letter dated December 4, 1987, requested inspection of the suit premises, which was refused by the first defendant. First defendant was not in possession. How could, my lord, a request for inspection be made to the first defendant, and how could it be refused by the first defendant? Because he had already parted with possession in 1974 under the second deed of lease or the deed of sublease. Then, the plaintiffs allege that the defendants are guilty of making unauthorized constructions and constructions in deviation of the sanction plan and have caused damage to the suit premises. In view of the breaches of the terms and conditions to the lease, the plaintiffs have got their advocate to issue a notice dated 16 December 87 determining the lease, calling upon the first defendant to remedy the breaches. How can the first defendant be called upon to remedy the breaches? And today, if the first defendant receives the notice, why does the first defendant not reply back saying that, look, I'm not in possession? And in default of the breaches being remedied for vacant possession after the expiry of the month of January 88. According to the plaintiffs, the first defendant did not remedy the breaches, and therefore, the plaintiffs are entitled to a decree for possession of the suit premises and mean profits. First defendant has filed a written statement denying the allegations made in the claim. First defendant claims that there was no valid determination of the lease. Plaintiffs had accepted tenancy of the first defendant even after institution of the suit. First defendant claims to be tenant under the plaintiff. First defendant claims that plaintiffs have accepted such tenancy by receiving rent from the first defendant after institution of the suit. First defendant denied having deviated from the sanction plan. Second defendant applied for and got itself added as a party defendant. Second defendant claims to be a subtenant in the suit premises in terms of the deed of lease. Such sublease being created by the first defendant in favor of the second defendant. Second defendant has filed its written statement. Second defendant claims that the first defendant executed a registered sublease dated 21st January 74 in its favor. Second defendant claims to be in possession of the suit premises consequent on the sublease dated 21st January 74. Second defendant claims to have paid monthly rent to the plaintiffs on and from 19th November 1992 till August 2000. Second defendant also claims it has been mutated in the records of the Kolkata Municipal Corporation along with the first defendant, and the second defendant has been paying municipal rates and taxes in respect of the said premises. Second defendant denies having violated any rules or bylaws of the Kolkata Municipal Corporation. No mention of, my lord.
Now that is what you see, when it was a contested suit, you have to show where is the collusion, okay?
Yes.
Which was suppressed, which
What
was done in collusion.
What I am trying to show to your lordship, as neither the plaintiff nor the defendant number 1 or the defendant number 2 makes any mention of the fact that a building was constructed. It's a multi-storied building, fully occupied, 874 odd tenants, and in respect of each of these tenants, registered agreements have been entered into, registered deeds of assignment have been given. Well, that is the suppression, that is the collusion. Because, my lord, with the greatest respect, if today it had been brought on record that, my lord, these are the, defendant number 2 or my lord, Mahavir properties that constructed a building, my lord, obviously upon obtaining requisite sanction from the Kolkata municipal authorities, my lord, then, my lord, pursuant to the power vested in it under the original deed of lease and then by the first deed of sublease, had granted subleases or assigned portions of the property, then the court would have insisted on the appearance of the other persons. Well, it is inconceivable that a court then would have also directed a decree against persons who would actually be physically prone to eviction or be liable to be evicted from the property without hearing them.
Whether they were necessary and proper parties.
Yes. And that brings me to the question here, the difference between a sublessee or a subtenant and a recognized sublessee or subtenant under the Transfer of Property Act. Then, please see the next paragraph. 6 issues were settled for trial on 13 September 2006. Here, issue number 2 is, was there valid determination of lease? Issue number 3, did the defendant fail to pay monthly rents as per positions embodied in the deed of lease? Now, your lordship will remember the rent was a princely amount of 9,000 rupees a month.
The area was how much?
Well, at 1,60,000 square feet. Well, initially, what was granted was lease of a land. Well, with some dilapidated structure standing thereon. Well, obviously, a lease premium was recovered, and then monthly lease rent of 9,000 rupees was fixed with periodic enhancements.
No, on that land, piece of land, lease was entered into.
Yes.
And with the authority to construct.
Yes.
That was there.
Now, the original lease deed, because here, the original lessor, that is, this date is under Morari Charan law, are now saying that you have not paid me rent. What is the rent?
The question is, when the suit was instituted, as per the schedule of property, it was shown only vacant land.
With some other structures which is not the building there. And under the lease, there was right to demolish those structures and to erect new structures.
And any allegations made regarding constructions made, but in violation of the...
Only 8,000 square feet. Now, let us assume for the sake of argument that there are two consequences follow. One is, there is a wrongful construction of 8,000 square feet, which no one has ever come forward to admit. Now, then at best, corporation could have been approached to direct demolition. No question of a civil suit.
No, question is, you see, only, the suit property, that is the scheduled land.
Yes.
And the bone of contention is this, 8,000 square feet has been unauthorizedly constructed.
Now, as soon as you admit that 8,000 square feet has been constructed unauthorizedly or authorizedly, You admit that there's a construction which has been made in the property.
Now that means that is disclosure before the court. That is not a suppression.
No.
Up to that,
No,
up
my
to
lord.
that much is disclosed.
My lord, what is disclosed? 8,000 square feet is, my lord, unauthorizedly constructed.
That means there is a construction.
But, my lord, that is, my lord,
the
my lord,
contention.
today, when we, my lord, plead facts.
That may not be factually correct because there may be much more
My
construction.
lord, the requirement of the Civil Procedure Code is to, my lord, plead facts clearly and
Now
succinctly.
the question is, you see, suppose it is not a, you see, suppression of material fact or collusiveness, then whether there is any irregularity in the decree, this court cannot sit in appeal. Okay, because
Right.
there is. So you may say that yes, these were not properly pleaded or schedule does not
That is all.
because that has ended, because that is this is finality. If you have to show your collusion,
That
then
is
you have
right.
to show what was necessary to be
That is
pleaded.
what I am trying to show. Now, my lord, today, when, my lord, I have to show collusion, my lord, today, if it is not stated that we have constructed a multi-story building of 1,60,000 square feet, inducted more than 800, my lord, sublessees and assignees in the property, then, my lord, the question is it material suppression amounting to fraud on court?
Yes. So, as per the plaintiff, it is 8,000 square feet is unauthorizedly constructed.
Right. On the roof. On the roof of the building.
On the roof of the building.
That is the statement. Well, at paragraph 10A. The defendant, in violation of rules and bylaws of the Calcutta Municipal Corporation and in breach of sanction plan for the said premises, constructed unauthorized structures covering about 8,000 square feet on the roof of the 8th floor of the demised premise. Now, my lord, there are two ways of looking at it. One is, my lord, this is, my lord, MOP, unauthorized construction.
Yes.
So, my lord, I
That
can
means,
terminate.
rightly or wrongly, some construction is made.
Yes.
Now that is alleged to be unauthorized. Okay,
Right.
that is the subject matter of suit.
Right.
That is one thing.
Right.
And the other thing is, nothing is brought before the court that there with regard to construction. Only there is a land.
Well, that is also true because, my lord, here the schedule of the plaintiff is only the land.
Yes.
Now, my lord, if your lordship, my lord,
Because that was the agreement. As per the lease, that was the
That's right.
agreement.
Now, my lord, today the schedule of the, my lord, plaintiff is only the land. And, my lord, stray utterances here and there, my lord, which are, my lord, very, very, what would I say, misleading as to, my lord, what is the construction. Now, my lord, even if today one, my lord, accepts that there's disclosure of construction, where is the disclosure of, my lord, this constructed area having been given to others? And that not one or two people, hundreds. Now, my lord, please see, my lord, the issues that are framed. Did the defendant, in violation of rules and bylaws of Kolkata Municipal Corporation and in breach of sanction plan, construct unauthorized structure? Are the plaintiffs entitled to decree? Now, my lord, please see, very important. The plaintiffs produced two witnesses. The first defendant did not produce any witness. The second defendant produced two witnesses and one witness is subpoena.
Second defendant is the sublessee.
Yes, Mahavir.
Is your original lessee.
Yes. Now, my lord, the defendant produces two witnesses, but none of them come forward to say that, my lord, there are 800 people occupying the building which is supposed to be partly unauthorizedly constructed. Then elaborate submissions are made, etc., etc.
Now, regarding that building, have you been able to collect the completion certificate from the municipal authority that when this building was completed?
Well, it is, my lord, not for me to collect. My lord, today it is upon...
No, because you see, suppose you want to show that this was nothing on record before the court to show that the building was constructed, there were occupants there, and all these things. So the question is, they have said that yes, there is unauthorized construction, building is there, but 8,000. But according to the in 1988, entire building was constructed.
That's right.
So have you been able to collect this?
I do not find anything on record to show that I have, my lord, found out or collected. But it is no one's contention.
Before moving this application, that this completion certificate would go to show that in 1988 this was constructed. That is the only thing.
No, my lord, I have আমাদের আছে recorded.
Sanction plan also.
Because you see, construction is there.
Yes.
Unless there is construction, how can it be unauthorized?
Right.
Definitely there is a construction.
Right.
But according to you, this entire constructions and entire this occupation by these people, this is not brought. So assuming I accept that occupations of the people is not brought, whether the construction existed at that time, 1988, that means there should be a completion certificate.
Right.
Or occupancy certificate.
Now, my lord, so far as that is concerned, so far as this application is concerned, I have stated that, my lord, construction was completed in accordance with plan in 1980. My learned friends have, my lord, consciously chosen not to file any opposition to, my lord, ultimately deny this, my lord, fact.
No, because you see, if you want to establish collusion, the court wants to know anyway. You submit.
I just tell your lordship this, that, my lord, when I assert that, my lord, the building was completed in 1980, when I assert that, my lord, registered subleases and assignments were executed in respect of, my lord, various spaces in the building, and, my lord, there is no denial because my learned friends, my lord, waived their right to.
Your lease is in which year? Your lease?
My lord, my leases are, my lord, from 1980 onwards.
1981, 80-81.
আমার লিজগুলো কবে থেকে আছে? My lord, from 81 onwards, after 81, not before 81. Well, I have annexed the lease documents. I shall show you, lordship.
Question is yes. You were 80-81. That means you were in occupation. Question is this. According to you, you see, the moment you see there is a contention that there is a construction, that means they have not totally suppressed. They have alleged construction, unauthorized construction. So according to they ought to have alleged the entire construction. So whether that construction
to take care of that argument, I shall show your lordship, my lord, today. Your lordship has heard of the expression, well, that a half truth is, my lord, more dangerous than a lie. My lord, here, my lord, with the greatest respect, our courts have held, the Supreme Court has held, that suppression means suppression of all material facts. Now, my lord, part disclosure will not be, my lord, disclosure of all material facts.
Because you see, suppose certain facts were taken into consideration, and even if there is some irregularity also, this court cannot sit in appeal. So you have to satisfy that there was two things, collusion.
No, my lord, here the court is not proceeding on whether the construction is legal or not legal. The court is proceeding on the premise that if today you have constructed an unauthorized construction or a part of an unauthorized structure in the suit premises, this is, my lord, violation of the lease terms and conditions, which would enable me to determine the lease. That is how, my lord, the plaintiff is, my lord, positioned. And that is how the court proceeds. My lord, please see the next paragraph, it will be clear.
Because you see, had there been no building and occupants, so whether there is unauthorized or authorized, it hardly would have mattered.
Right.
Okay. Now the question is this, whether there was a suppression of material facts and whether these acts will go to show collusion.
I will show to your lordship, my lord, the judgments. I have not come to the judgments because I just want to finish, my lord, my narration on fact.
Yes, please.
My lord, material fact, what is? My lord, on that, my lord, there's sufficient discourse, my lord, in our jurisprudence. And, my lord, today, my lord, when you don't disclose the fact that, my lord, you have constructed an entire building of 1,60,000 square feet and inducted person, my lord, this part disclosure is not, my lord, disclosure, my lord, which will ultimately avoid the consequences of, my lord, suppression and consequently fraud. That I shall come to your lordship. My lord, I'm just trying to give you lordship. Now kindly see how the decree proceeds. My lord, at page 2319, the first two issues are taken up for consideration. The lease dated 20th April 1964 being Exhibit B contains various terms and conditions. It interiorly provides that any 2319.
Yes.
Provides that any breach or non-observation of any covenant or condition will entitle the lessor to determine the lease and enter upon the demise premises. So, my lord, that is what they are going on. They're saying if you have made an unauthorized construction of 8,000 square feet, then, my lord, it is good enough ground to terminate. Now, my lord, pausing here for a moment, your lordship will remember I had shown your lordship from the lease deed that, my lord, today an opportunity must be given to cure the breach if there's a breach. Now, my lord, who gets that opportunity, if at all? Defendant number 1, who has not constructed. No opportunity to defendant number 2, who has constructed. No opportunity to other defendants who are in fact residing and occupying, including the so-called 8,000 square feet, which is unauthorized construction. Then, my lord, the plaintiffs claim that the defendants committed breaches of the terms and conditions of the lease. Defendants deny that there was any breach. Now, my lord, defendants deny with no breach because, my lord, defendant number one does not even lead evidence or produce witnesses. Section 111G of the Transfer of Property Act allows lessee to determine a lease to re-enter the demised premises after giving notice in writing. In the instant case, plaintiffs determine the lease by letter dated such and such. In the written notes of argument, second defendant claims that Exhibit F, well, this is the notice, was not served upon in spite of the plaintiffs having knowledge of transfer of possession on execution of sublease in favor of the second defendant. Notice dated 16 December 1987, being Exhibit F, is addressed to the first defendant. First defendant is the lessor, second defendant is the sublessee. Second defendant has not established by evidence that the plaintiffs were aware of the execution of the sublease. Now, my lord, may I pause here for a moment? My lord, they have not, my lord, led evidence to show that the plaintiffs were aware of the creation of the sublease in their favor. My lord, let us, my lord, just, my lord, take a moment to reflect on this. Now, my lord, it is a registered deed of sublease, executed pursuant to right given under the original deed of lease. But, my lord, the parties do not come forward to assert that, yes, you knew. Now, my lord, today, the law is very, very clear that a registered document is, my lord, constructive knowledge. Then, my lord, kindly see. The plaintiffs have issued the notice for remedying the breaches and default for exercise of the right of re-entry to the lessor, the first defendant. The second defendant is bound by the actions of the first defendant. Second defendant traces its rights through the deed of lease. The right of the sublessor, the second defendant, cannot be higher or greater than the rights of the first defendant. Now, my lord, here, my lord, I shall show you, lordship, that, my lord, so far as, my lord, rectifying or remedying breaches are concerned, which is, my lord, section 114 and 114.
That means, you see, so far these two defendants are concerned, the matter has come to an end.
Yes.
Now it is only your client
Naturally.
or the others.
My lord, they have, my lord, colluded to bring the matter to an end amongst
They were heard, and anyway, so far
That's
their
it.
rights are concerned, it has come to an end.
Yes.
As per the observation.
Now, my lord, what is held? That, my lord, there was a notice given to cure the breach, and breach is not cured. Now, my lord, today, my lord, what would be the natural consequence? You're saying 8,000 square feet is unauthorizedly erected. Let me show you evidence as to why it is not. Who will produce the evidence? Defendant number 2 or Mahabir Properties. Who will, my lord, produce evidence? Who, if at all, it's required to do so? Through the defendant number 1, Marshall and Son. None of them come forward. Then, my lord, please see the next paragraph. In its written statement, the first defendant does not deny the receipt of the notice dated 16 December 1987, being Exhibit F. In paragraph 20 of the written statement of the first defendant, as rightly pointed to plaintiff, first defendant denies and disputes the contents, validity, and legality, but does not deny, my lord, the notice. Receipt of Exhibit F is not denied, as rightly pointed out. Plaintiff's Exhibit F refers to a notice, says dated November 26, 87, being Exhibit C, and December 1, 87, being Exhibit D. Exhibit F also records that the first defendant is a defaulter in payment of rent since October 87. The plaintiffs, through Exhibit F, called upon the first defendant to remedy the breaches, and in default of such breaches being remedied, to vacate the demised premises. Exhibit F is therefore a combined notice under 111G and 114A of the Transfer of Property. Now, I shall show you, lordship, that, my lord, under 114A, a subtenant or a registered subtenant or a, my lord, recognized subtenant has a right to, my lord, ultimately, my lord, clear, my lord, any breach or to remedy any breach. None of the defendants established that the breaches complained by Exhibit F were remedied prior to January 87. Second defendant claims that the notice of determination, being Exhibit F, was not served upon the first defendant. Such claim is misplaced if the first defendant does not dispute receipt of the notice. Exhibit F was written in the context of requisition for inspection as well as allegation of construction beyond terms. In such circumstances, therefore, the first two issues are required to be answered in the affirmative in favor of the plaintiff. So, my lord, what is answered in favor of the plaintiff? That yes, there was a notice served. On whom was it served? On the defendant number 1, requiring him to what? To remedy the breach. Defendant number 1 did not do so. Defendant number 2, my lord, did not do so. Defendant number 2 did not prove that defendant number 1 had notice of his existence, and hence, my lord, the issue is accepted. My lord, may I come back, my lord, on the next day at 3 o'clock, my lord? হ্যাঁ হ্যাঁ স্যার ভয় পেয়ে গেলাম
Okay.
Lord, I have Lord, the applications which were not appearing. Lord, I am appearing in few of the applications. After he finishes, Lordship gives me 15 to 20 minutes on the board.
These
Those are not in
applications
the
are
list.
appearing today.
GA9. Well, let me first finish, then my lord.
Actually, let
GA9 and 14 will
no, if they are not appearing, give the slip. It
Yes,
will
I'm
appear.
giving this slip. Lordship will give me time so he can give a my learner
Yes,
can give a
record an order.
composite reply.
No, no, let this one be completed first. Learned advocates for the parties are present. Mr. Shaha, learned counsel for GA 44 of 2025 submits but could not conclude the same. Yes, on the next occasion, you please conclude.
I will not waste your lordship's time, but my lord, there are a number of judgments I'll have to show also. But I will, my lord, try to be as quick as possible. But my lord, I have to bring to your lordship's notice, my lord, some relevant things.
Let this matter appear on. I'm keeping it on 16.
As you lordship please.
16/9/2025 at 2 p.m.
16. Great, very well.
Before the vacation, my learned friend is trying to threaten my lord, your lordship, as also me, with my lord volumes of decisions which he is going to cite.
Well, I will actually cite. I'm not threatening to cite them. I will actually cite them.
But after you cite, now you are threatening, then you actually cite.
Yes, you conclude the facts on the next day as
Yes,
well
yes.
as the judgments, you see.
Judgment-
Facts you have argued, or 2-3 days you have argued on the fact.
Well, I will, my lord, finish the facts very quickly because, my lord, I am just showing your lordship the decree. But, my lord, then I shall proceed
And you
with the
can
judgment.
cover it in your written notes also, all these
My lord,
things.
no, my lord. This matter is very important. My lord, 800 families, my lord, and their lives are dependent on this.
Because I'm not hearing any other applications. I'm
Well,
only hearing your application.
your lordship can take it from him. I shall not repeat myself, but my lord, I shall have to, my lord, take your lordship through some of the, my lord, judgments and the, my lord, relevant portion of the law. My lord, if written notes or arguments had sufficed, then, my lord, we would not have argued before your lordship.
Fraud was so clear, it would have taken so long to establish.
And you have also taken the risk not to file the opposition.
No, my lord, because law is so clear, Mr. Mitro's client obtained the decree on the blinking of an eye.
Yes.
Blinking of an eye.
Milord, one thing, Milord, on the last day.
Lord, may I have your lordship, please?
Should not give us, Milord, liberty to inspect the record.
17 years.
We have to, Milord, inspect the suit record, Milord. They are only allowing us the execution proceeding because, Milord, whatever questions are falling from your lordship, Milord, today, we need to, Milord, see whether they were there in evidence.
Well, may I have your lordship's leave,
So
my
for the time being, let this hearing be.
Milord, for that only, in order to assist your lordship only, we need to see, Milord, the evidence.
Well, kindly give me your lordship.
Just that, Milord, this record must be, Milord, the suit records. Kindly, Milord, allows that. I have made applications also, Milord, in that.
Okay. For which applicant you are appearing for?
Milord, I am for, Milord, 16 to,
The suit record.
17, 18.
The suit record may be inspected by learned advocate for the applicant.
Let it. I also will.
Of GA.
Milord, I have
GA
9 and 14. আমারটাও করে দাও না।
আমি এটা বলে দিই দাঁড়াও।
GA
16 to 18.
16 to 18.
45, 61 to 63.
45, 61 to 63.
And
Okay,
also
let one
also
part be
for
over.
9 or 14, Milord. Also 9 and 14 since lordship is given.
9 and 14.
9 and 14.
Also Mr. Shah's.
No. You first take up your cause.
Very well, very well.
তুমি সবাইকার হয়ে বলছো, হ্যাঁ?
Let Mr. Shah complete thereafter.
Very well, Milord. I'm deeply obliged.
Great.
সবাই মিলে মারপিট করবে কি ডিপার্টমেন্টে আমি sure.
আজকে ব্রহ্মাস্ত্র নিয়ে এসছি আর আমরা পালিয়ে যাচ্ছি।
Yes. Appellate set matters.
লিস্টে নিয়ে আসলাম, লিস্টে নেই। রেকর্ড করুন। Good record. The inspection of the suit record.
Yes, I've clarified that.
Yes, wait. My lordship,
Yes.
upon compelling circumstances.
Yes. What is that?
My lord, my lord, this was the order, my lord, and it was of to fix the matter today
in between the first five matters. Now it is appearing as item number 132 of the list, my lord.
143,
Okay.
39,
134.
132.
একই জায়গায় ঘুরছে
ঠিক আছে তুই আমি বলছি আমি urgency দেখতে
I'm just passing. Let this matter
my lord's
appear. Let this matter appear. Hey, record করুন তো order.
My lord is keeping this matter to
Yes, item 134. Let this matter.
132, my lord.
Yes.
132 of the
Item
list.
number 132. Let this matter appear on 11/9/2025.
Kindly keeps it tomorrow, my lord, 10th.
Why?
My lord,
I'm keeping it on 11, day after tomorrow, within first 10 matters. Okay.
my lord, it was regarding the transfer of the investigation which was arbitrary.
রাখছি তো ফার্স্ট 10 ম্যাটার্স ও কবে রাখছি
Okay, you see, item number 11, I'm just keeping it within first 10 matters. If there is some difficulty, I shall take it upon mentioning.
with my lord's kind leave to mention, my lord, item number 39,
Yes.
my lord, in case the matter is not taken,
Yes,
my lord,
item
item number 39, in case the matter is not taken up today, my lord, you kindly keep it up tomorrow. We'll fix it up tomorrow, my lord, have some urgency.
Item 39.
Yes.
Okay, if it is not taken up today, tomorrow you mention at the first sitting.
My lord, I'll do that.
Yes.
I'm grateful, my lord.
132.
Let's start item number 1.
Yes, today is fixed for filing the written notes of arguments.
Yes, sir. Mr. Banerjee wanted to make some submission of what?
No, question is arguments are complete. Only thing is this only filing of written notes is left. Yes, yes, record an order. Mr. Srivastav, learned counsel for the opposite party, filed its written notes of arguments. Let it be kept with the record. Let this matter appear on 12/9/2025 for filing written notes of argument.
He had filed. His argument is on record.
Okay, let this matter appear on 12/9/2000. If it does not appear, I shall treat the matter to be concluded. Let this Mr. Srivastav, learned counsel for the opposite party, files written notes of arguments. Let it be kept with the record. Fix the matter on 12/9/2025 under the head to be mentioned.
Number 2.
Well, item number 2, I am appealing for the petitioner led by Mr. Ashim Kumar Raut.
For opposite party number 1, my lord, I'm led by Mr. Shakko Sen.
I think the hearing was concluded, only
Yes,
written
sir.
notes of arguments that were filed.
We had
I'm
fi-
keeping it on Friday, or are you ready?
My lord, written notes we had filed on the last day, my lord.
Both of we have filed our written notes of submission.
So hearing can be treated to be concluded?
Yes, ma'am.
Yes.
Yes, record an order. Learned advocates for
Kindly keeps it on 19th, my lord. Mr. Sen
Learned-
is coming.
I'm keeping it on 19.
19th, my lord.
Learned advocates for the parties are present. Let the written notes of arguments filed by
Already filed.
by
Last
the
occasion.
okay, already filed.
Yes.
The learned advocates for the parties are present. Let this matter appear on 19/9/2025 under the heading to be mentioned.
In case, my lord, my senior wants to submit something, my lord, my senior.
Yes. But on that day it will be concluded.
Namdin. Item number 3.
My lord, I appear for the petition. Now, my lord, kindly sees the order impugned in this application. Now, my lord, we are the accused. Now, my lord, PW1 and PW4, my lord, they both are family members of the deceased. It's a case under section 304. Factually, my lord, what had happened was there was a quarrel last night. Thereafter, the person.
Question is, which is the order? Let me
But
see.
kindly comes order number 31 dated 16 June 2025. It's a part of the certified copy.
Order number 31. Yes.
Now kindly seize the order. Today is fixed for hearing of the petition dated 11th December 23 relating to the petition under section 231(2). Learned advocate of both sides are very much present, heard their submissions considered. All the 5 accused persons on bail are absent and represented through their advocate by filing a petition under section 317, heard both sides considered. Learned advocate appearing for the accused submitted a petition praying for allowing the petition under section 231 CRPC, inserting the ground therein, and wants to cross-examine witness numbers 1 to 4. 1 to 4 are family members. 1 is Pratibha, the wife of the deceased. 4 is Manav, the brother of the deceased. Describing the fact that in the petition with a prayer for allowing the same, learned PP is very much present to submit that it is an offence under section 304 of IPC, and examination in chief of PW1 has last take on 11 December 23 and to be continued, and at this juncture the petition under section 231 CRPC has been filed and pending for disposal, and this court have gone through the contents of the petition and also heard the submissions of the learned advocate of both sides, and also from the case record wherefrom it appears that facts of the case relates to an incident of 23rd November 2013, and the trial of that incident has commenced on 1/1/20, and since then thereafter till today the evidence of PW1 has not been completed, and this court, after going through the contents of the petition under section 231, does not find any justifiable cause. But 1 and 4 are admittedly the family members of the deceased. Kindly comes to my petition under section 231. The next page. Kindly comes to paragraph 5.
Cross-examination of PW1 is not yet completed.
Yes, not yet completed.
But examination in chief is
Chief is
completed.
completed.
Thereafter you file this
Yes,
petition.
we filed this 231 saying that we will cross-examine after the evidence of PW4 is over, because he is a family member. Kindly comes to paragraph 5, that your petitioners want to cross-examine prosecution witness numbers 1 and 4, namely Pratibha and Manav, after prosecution examination, as both are the same family members.
Okay, when is the next date fixed?
Tomorrow.
Yes, record an order.
But I was praying for a stay of the proceedings.
Learned advocates for the petitioner is present. Heard learned advocate for the petitioner. This matter is taken up on urgent basis on the ground of exigency. It is the contention of the petitioner that the witness being PW1 and PW4 are being fair family members, and for this purpose the petition under section 231(2) of the Code of Criminal Procedure, petition under section 231(2) of the Code of Criminal Procedure 1973 was filed. Stop. To defer the cross-examination after completion of the deposition of PW1 and PW4. Stop. It is further contended that the learned trial judge, without assigning in resin, has dismissed the said application merely on the ground that the trial is pending for a long period and evidence of PW1 is not yet complete. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 7 days. An affidavit of service be filed forthwith. Let this matter appear on the reopening date of the vacation. Pending hearing of this application, there shall be stay of further proceedings in
But of ST number 1120, SC number 15819, pending before learned additional sessions at 17th Court, Alipur.
in ST number 01 within bracket 01 20 stroke SC number 15 within bracket 8 19 arising out of Bishnupur PS case number 306 of 2014 dated 25th March 2014 for a period of 1 week after vacation.
Grateful. Item number 4, I am for the petition, my lord. My lord, it is a case where the petitioner, who is a husband, my lord, father-in-law and mother-in-law, my lord, what happened is a dispute crops up out of a matrimonial discord. My lord, a mutual divorce was filed by both the parties. That mutual divorce has been decreed. My lord, your lordship will find that decree at page 72, my lord. And the date of that decree 6/8/2024. My lord, during pendency of that, my lord, FIR has been instituted by the wife. And later, my lord, the wife has also given a letter to the investigating officer that has been given to us by the wife itself. At page 77 is the letter. And also, my lord, I am covered by 2 judgments of the Honorable Supreme Court, where once a mutual divorce is attained, the wife at the same time cannot pursue a criminal case.
Yes. But is any order is?
Yes, my lord. I will take
Order?
your lordship. My lord, kindly come to page 72 of the application.
2 years. No, 72 is the final order.
Yes, my lord.
Okay. Any petition have you?
Yes, my lord. That
Before
petition.
the trial court.
Yes, my lord. That petition your lordship will find at page 19.
Page?
19.
90.
19, my lord.
19.
My lord, this is the application on the basis of which your lordship has found that order being passed.
Yes.
Page 19 is the application. Thereafter, your lordship find page 72 is
the application is for on this dissolution, suit for dissolution.
Right.
Okay. Now, pursuant to the dissolution, did the de facto complainant file any petition that she is not willing to?
No, my lord, that has not been done. What she has done is,
Yes.
my lord, page 77.
Page 77.
Yes. And my lord, irrespective of the fact whether she has log
77.
Yes, ma'am. That is the letter given by the wife. The difficulty is that the wife, after obtaining the mutual divorce, now has become less interested with the entire litigation. Otherwise, we could have filed a joint compromise application. But be that as it may, my lord, I am covered by 2 judgments. I will show your lordship where the Honorable Supreme Court said that once a wife enters into a mutual divorce and that is comes on the affidavit, she cannot at the same time pursue a criminal litigation. 2 judgments I will refer, my lord. First is 2005 3 SCC 302. My lord will kindly see para 9 to 16. This is, sorry, my lord, I have handed Mohammed Shamim.
Yes. Para 9.
9 to 16. 9 is the. No. 1 second. And in this matter also, the wife has received a substantial payment. That check and everything is part of the mutual settlement. That is part of my application. Paragraph 16 is the culmination of the observation, where on the one hand, the mutual divorce taking place, settlement amount is being received. On the other hand, criminal proceeding being pursued.
Yes, record an order.
And I have another judgment if your lordship wants.
Learned advocate for the petitioner is present, or learned advocate for the petitioner. The petitioner in this case has sought for quashing of here case number 2773 of 2024 arising out of Dom PS case number 153 of 2024 dated 21st April 2024 pending before learned 5th Judicial Magistrate at Barakpur. Top. It is the contention of the petitioner that although marriage between the petitioner and Yes, there are three petition. Petitioner number one is the husband.
Petition number one is the husband,
Okay,
two is the
petitioner
father-in-law,
number
three is
one.
the mother-in-law.
And the opposite party number two is dissolved by a mutual decree under section 13B of the Hindu Marriage Act 1955. But the instant case, which is still pending before the learned magistrate, is not yet dropped. Learned advocate also draws the attention to the letter issued by the de facto complainant, opposite party number two, wherein the de facto complainant expressed her intention to withdraw from the case as the matter is settled. Learned advocate relies upon a decision of the Honorable Supreme Court in the matter of Muhammad Shamim and others versus Nahid Begum, within bracket SMT, and another, reported in 2005, 3 SCC, page 302. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week. An affidavit of service be filed forthwith. Let this matter appear 2 weeks after vacation. Pending hearing of this application, there shall be stay of further proceedings in here case number 2773 of 2024, which is pending before learned 5th Judicial Magistrate at Barakpur for a period of 4 weeks after vacation.
Much.
Number 5. 6. 6, my lord, I am appearing for the petitioner, my lord. I am being led by Mr. Sadudul Laidi in this matter, my lord. I am seeking an adjournment, my lord.
Okay, not today.
Grateful.
So when I'm for the petition. In this matter, my lord, I'm praying for expeditious disposal of a case, my lord, instituted in the year, my lord, 2012.
Let me see. The case is pending where?
Case is pending before the learned Additional Chief Judicial Magistrate, Srirampur, Hooghly. In the case of 2012, my lord, charge sheet submitted. One of the accused is, my lord, still absconding. My lord, I am praying, my lord, Lordship kindly direct the learned magistrate to take resort to, my lord, 317(2), my lord, to split up the trial and, my lord, to expedite the proceeding.
Okay, it would be better if I hear the other side and thereafter pass the orders. Yes, learned advocate for the petitioner is present. Heard learned advocate for the petitioner. Upon hearing the petitioner and upon considering the case, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the learned public prosecutor. And let this matter appear on 15/9/2025.
Next.
Under the same heading.
My lord, diploma. My lord, can it retain its position, my lord?
Yes, let it retain its position.
Let it. Diploma.
Number 8.
Lordship, I am praying for a short passover as my land senior counsel in court number 26.
Okay, passover.
Number 9.
My lord, I am praying for the petitioner, my lord. I am praying for a quashing of proceedings arising out of electronic.
Yes, item 9.
Oh, sorry. I am praying for a quashing of proceedings arising out of a electronic PS case number 75 of 2024. started under section 381, my lord. The petitioner happens to be the employee of a particular company, my lord.
Yes.
The petitioner happens to be an employee. The FIR, the complaint, if my lord may kindly come down to the complaint once, states that at the time of employment, they handed me over a laptop and a mobile phone. And after,
Yes.
yes,
Page?
my lord, the certified copy is, my lord.
Oh, certified copy of the complaint.
Yes, my lord.
Yes.
My lord, the third paragraph starting from, please note that when we appointed such and such, we gave him a laptop and a mobile phone bearing official number such and such. Suddenly, he stopped coming to our corporate office from April 22nd. My lord, may kindly note this date. Like, I'm coming back to this again. After putting the office under lock, we tried to call him on his number, but his phones were switched off. Please note that he has phone laptop given by the company which contains confidential information. This is the allegations, my lord. My lord, may kindly now come down to page number 24. They have suppressed that we have a communication. The accused person, that the petitioner right now, has communicated his resignation, wherein he has categorically stated that he is trying to resign and he has intent to hand over the mobile phone and the laptop back to the office.
No,
My lord,
that is prior to this complaint.
yes, my lord, on 20th of April.
Page?
Page 24, my lord. Oh. That is page 24, my lord.
Yes.
He has mailed the HR through his official email because at that point of time he did not resign from the post. That is on 20th April 2024, my lord. My lord, then take the last paragraph. Please note to whom I will hand over. He intends to hand it over. The company valuables, one laptop, one phone, and Sitco office key. So whatever that was there lying with him, he intends to return it back. The company returns.
Was this seized by the IO, this letter?
Later it was seized because IO has not conducted any preliminary inquiry after the complaint was.
The IO interrogated you?
No, my lord.
You are now on bail.
I am on bail, my lord. I'm asking for a quashing of this proceedings, my lord. Say why, my lord. I am not intending to steal this. If there was a preliminary inquiry conducted by the IO after receiving the complaint was received on 4th of May.
Charge sheet is submitted.
Charge sheet is submitted, my lord. The problem is, my lord, if I was in intention to steal that, then there would have been an FIR. There was a complaint that I was not returning that back. My intentions were never to steal because I have already communicated. And in that communication, they have replied me back. After replying me back, again, I have categorically said that my lord may kindly come back to 22nd of April. And in their complaint, they have suppressed the email. They have suppressed the communication that they had with me in the email ID.
So nothing is recovered from you?
Recovered because it was lying with me only, my lord. Had it been there a preliminary inquiry conducted before taking the complaint, the police has, this FIR is an ego FIR, my lord. After receiving the complaint, the police drawn a FIR under 381, which is more less than 7 years, my lord, or maximum up to 7 years.
So
no 41 notice was served, my lord.
So what is seized from you?
The phone and laptop and the key. That's it, my lord.
Okay, let me see the seizure list.
Yes, my lord. The seizure list is in page number 19, my lord. Just because I wanted to resign, my lord, the company didn't take it in a well way. They have lost this FIR, my lord. Dada. Give his name now. And in the first mail, my lord may kindly keep that in mind, my lord. In the first mail, I have intended to return all this, my lord.
What is this seizure list? This is another is 11/5/2024.
That is, my lord, my employment documents and everything that they have seized from the complainant, my lord. This is a motivated FIR, my lord. If the police ought to have conducted a preliminary inquiry, my lord, they would have asked me to come to the police station. They would have asked me whether I am intending to give it back or not. That would have been clear there itself, my lord. Unnecessary pulling up an FIR and taking a person into custody. I was arrested at 3 o'clock in my place, my lords. That too also for 381.
Yes. Learned advocate for the petitioner is present. Hard learned advocate for the petitioner. The petitioner in the instant case has sought for washing. Here, case number 526 of 2024, presently pending before learned additional chief judicial magistrate at Bidhan Nagar. Stop. It is the contention of the petitioner that the petitioner is falsely implicated in the instant case as because he intended to resign from the office of the de facto complainant. Learned advocate draws attention to the letter of resignation issued by the petitioner to the de facto complainant, which contains the desire to return the laptop and the mobile phone, which includes the desire to hand over the laptop and mobile phone. Learned advocate also draws attention to the letter handing over the mobile phone and the laptop. Stop. Upon perusal of the petition and upon hearing the learned advocates and considering the complaint, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week. An affidavit of service be filed forthwith. Let this matter appear on 20. Let this matter appear 1 week after vacation. Let the case diary be produced.
My lord,
on the
for the
date
stay
fixed.
for the timing, my lord.
Yes.
Stay of proceedings for the time.
Let the case diary be produced. Pending hearing of this application, there shall be stay of further proceedings in GR number 526 of 2024, pending before learned additional chief judicial magistrate at Bidhan Nagar for a period of 3 weeks after vacation.
Grateful. Thank you. Grateful.
Yes.
My lord, I'm for the private opposite party wife.
My lord, I am for the petitioner husband, my lord.
What is this CRAN?
My lord,
Section 5, my lord.
Section 5 application, my lord. Copy has already been served upon them, my lord.
Has it been allowed?
No, this is the first time this matter is appearing.
This is appearing for the first time.
Yes, my lord. But my lord, copy has been served upon them, my lord. There is a delay of 21 days.
Yes, what are the facts of this case?
My lord.
এই CRAN টা দেখি
দাদা
আছে এর মধ্যে? There is delay of 21 days.
21 days, my lord. 21 days, my lord.
Yes.
Yes, my lord. My lord, this is my application, my lord. Initially, what has happened, my lord? The order has been passed by the learned trial judge in ex parte manner, my lord. The order has been passed against me of rupees 8,000 per month. That was an ex parte order against me. And my lord, that order has been passed on the date where there is a resolution of not to pass any adverse order before the trial court below, my lord. If my lord kindly comes to page 23, my lord, I have already annexed the 23 and 24, my lord. I have annexed the resolution, my lord. This is the first resolution, my lord, 17/3/2023.
Yes.
And on the next page, that is, my lord, 24, my lord, the resolution dated 14th June 2023. And my lord, the resolution was for 2 days, that is 15/6/2023 to 17/6/2023. And my lord, the order has been passed on 16th of June 2023. That is, my lord, within the day where there is a resolution of not to pass any interim. 16/6/2023, my lord.
Page.
My lord, page, my lord, page 16, my lord, 15, my lord. Page 15.
Page 15. No, at the date of passing the order, presence of advocate is not necessary. After hearing is concluded,
But my lord,
orders are being passed.
but
So
my
what
lord,
is the necessary of your presence?
But my lord, prior to this, there was an application filed by me. That was the ex parte vacating application. And that application has not been entertained, my lord. That
No, application for vacating what? Interim order.
ex parte order. Ex parte order.
You see, the order prior to that, you were heard, definitely.
No, my lord.
No, when it was fixed.
Previously, there were also resolution of not to pass on the date when the case was fixed.
So did you file any application for recalling this order?
Yes, my lord.
Where is that?
My lord, may I only humbly indicate one thing? My lord, this is not the impugned order that is challenged before your lordship.
The order passed by the appeal court.
That is the order passed by.
My lord, impugned order is, my lord, the sessions court order, my lord. That is
Yes.
order dated 18th March 2025, my lord. Now, what my learned friend is submitting, my lord, that is with regard to the magistrate's final judgment.
Is that they preferred an appeal?
Yes, my lord.
They have
And
preferred an appeal. They are agreeing
lord,
with that.
my lord,
They have
they-
come before your lordship,
Yes.
challenging the sessions
18/3/2025.
Exactly.
18/3/2025.
These resolutions.
My lord, this is the, my lord, the background of the case, my lord.
These were considered by the appeal court.
Unfortunately, my lord, this has not been
Against that
considered.
order?
And if my lord kindly comes to the impugned portion of the impugned order, the ordering portion.
So there was a direction to deposit 80,000. How much
80,000.
amount is, how much amount you are liable to pay in terms of the order?
My lord, I have already paid 30,000. Now, my lord, this is
No,
the order.
how
my
much
lord,
you
I
are
have-
liable to pay in terms of the order?
86,000.
Yes?
1,86,000.
How much he has already paid?
30,000.
My lord, there is a now, my
Right
lord.
now, dues are 1,86,000.
Now, if
Now,
my lord
if I
kindly
also
comes to the
indicate, after my learned friend finishes, my lord, kindly allows me to place my case.
my lord, there is already an execution case pending against me, and warrant has been issued against me. In prior to this date, I have already arrested and I have paid rupees 30,000, and thereafter I was granted bail, and again warrant of arrest. And on the same month, my lord, again warrant has been issued against me, and there is a direction to pay 42,000 by 20. By this month, my lord, September 22. This is
My
the
lord,
order
these
of
are
the.
not before your lordship, my lord.
These are execution case.
My lord, my lord.
Unless these orders are varied, okay, the order remains. So one thing is there, that if you deposit this 80,000, these orders, all orders of the magistrate will remain stayed.
My lord, I have challenged this order, my lord. My lord, I have come up before your lordship, my lord, only on the sole ground that I have not been given any opportunity of being
This is
heard
an interim order, interim maintenance.
No, my lord. The matter has been disposed of. This is the final order, my lord.
My lord,
Expert
that
order.
is talking about the magistrate's order, my lord. The sessions court, my lord.
Oh,
sees-
magistrate's order, my case is
That is
disposed.
the
How much is awarded?
My lord, 8,000 per month.
8,000 per month?
Has been awarded. That is the expertise order.
No, 8,000 in favor of?
My lord, may I say, my lord?
Yes.
My lord, 5,000 per month to me and 3,000 per month to
minor.
my minor child.
8,000
From
is
the
the
date
daughter,
of
my lord.
passing of the order. That is from 16 June 2023. This is the magistrate's order.
So,
Now, my lord,
so suppose you clear all the areas with regard to the child. How much is due and payable with regard to the child? Yes, can you give any idea with regard to the child?
86,000.
Unlike 86,000, suppose you break up 5,000 and 3,000.
3,000.
Okay. And assuming without prejudice to your rights, if 3,000 with regard to the child is to be cleared up entirely, how much it comes to?
My lord, that I'll take instructions, my lord. But may I only indicate one more thing to your lordship? My lord, if your lordship would kindly seize the averments in the petition, my lord. The subject matter is, my lord, where they have challenged the order dated 18th March 2025, my lord. But however, my lord, if your lordship would kindly seize the averments made in the petition, my lord, your lordship would find there is no averment to the effect how he has been aggrieved by the order dated 18th March 2025. He is aggrieved with the order dated 16 June 2023 passed by the learned magistrate. And here he has challenged the sessions court order and he has made no averments to that effect, my lord. Kindly, my lord, kindly.
Anyway, the grounds he has stated in the grounds.
My lord, I have already stated the
grounds he has stated.
every ground.
Anyway, some of the grounds he has stated that.
Those are all with regard to
Now
the
the
magistrate
question, now the
order.
question is, you see, you have paid till today. You have paid 30,000. When was the order passed?
The initial order, my lord.
Yes, yes.
See, June 2023.
June
16 June 2023 magistrate's order.
June
Final
23.
judge.
So 2 years have passed probably.
2 years, my lord. 2 years, 2 months.
So from June 2023 to August 2025, my lord, 8,000.
Suppose 2 years have passed.
2 years have passed.
2 years till for 2 years they have paid 30,000.
At the time when he was arrested in the execution.
30,000. Suppose you clear all the dues with regard to the child.
With regard to the child only, then my lord,
So
it will come
72,000.
72,000.
So clear the due, then I shall consider. So 30,000 pay 42,000.
42,000 remaining.
42,000 you pay. How much there was anyway? 42,000 you pay.
I am supposed to pay 42,000. If my lord.
No, without prejudice to the rights.
Yes.
And go on paying the current.
My lord, I am
The
paying
current.
the current.
The current you are paying.
No, man.
Yes, record an order. Learned advocates for the parties are present. Heard learned advocates. The petitioner in the instant case is aggrieved by the order passed by the learned additional Chief Judicial Magistrate Uluberia in
To submit a bond.
2022 ছিল 30 দিয়েছে 42
in Miss Case 135 of 2022. And the order passed by learned additional sessions judge second court Uluberia Howrah in directing deposit of rupees 80,000 in lieu of security with the court of learned SCGM Uluberia with the court of learned SCGM Uluberia. Upon hearing the learned advocates, this court is of the view that this matter should be admitted. Thus, I admit this application as the opposite party. আচ্ছা সবার উপরে করে দেবেন the delay in filing this application is considered and condoned. Yeah. Thus, I admit this application. As the opposite party has appeared, service of notice upon the opposite party is dispensed with. Let this matter appear 1 week after vacation. Pending hearing of this application, there shall be a stay. Yes, where is the execution case? Miss case number 135.
My lord, this is the execution case, my lord, 50 of 24, my lord.
Okay.
Pending before ACJM.
Okay.
Pending before ACJM. This is the
Pending hearing of this application, there shall be a stay.
My lord, kindly not grant a stay, my lord. Stay is not required, my lord. Why?
No, order of the stay. Order passed by the learned Additional Chief Judicial Magistrate on 16/6/2023 in Miss Case number 135 of 2022 on condition that the petitioner shall go on paying rupees 8,000 to the opposite party within
From the
10th
date of passing of the order.
No, within 10th of each
month,
succeeding month,
Seventh.
and shall pay
7th day.
rupees 42,000 within 15 days.
My lord, madam, kindly make it installment, my lord. I will pay.
No, 42,000. Okay, 42,000.
42,000 in installment.
42,000 within by 2 installments. The first installment shall be paid on or before 1/10/2025, and the second on or before 1/11/2025. Let this matter appear 2 weeks after vacation.
Deeply obliged.
My lord, if I have a request, my lord, if this matter be sent to the mediation, my
I can do that, yes.
My lord, let us come back, my lord. Thereafter.
Why you are let it? You see, if the mediation proceedings fails, the court can take up the matter. Okay, upon
As your lordship.
at the suggestion of the parties and upon considering the facts of the case, this court is of the view that as this matter relates to a matrimonial disputes, in the interest of justice, the matter may be sent to mediation for settlement. Thus, I refer this matter to mediation. Learned mediator is requested to take steps so that the dispute is resolved between the parties amicably. The parties are to appear before the learned mediator as on the dates to be fixed in this regard. Dash is appointed as the learned mediator. Let this matter appear on 3/11/2025 for report of the mediator.
Deeply obliged, my lord. Deeply obliged.
No. Dispose the report of the mediator. Grant. That is disposed. Granted disposed.
Whatsoever matter item number 8.
My lord, I am for the petition. My lord, let us start from page 26, my lord, which is a formal FIR. My lord, I am the complainant in that particular complaint. My lord, I had alleged, my lord, forgery of deeds and, my lord, grabbing away of land. Yes. At page 26, my lord, will find the formal FIR. Kindly see, notes the sections, my lord. It is 420, 468, 471, 120B of the Indian Penal Code.
Page 27, 26.
26.
Yes.
My lord, kindly see the formal FIR, the sections, my lord. 420, 468, 471, 120B. Thereafter, my lord, nothing was moving, my lord, according to the desired pace and direction. compelling, my lord, the complainant to approach the Honorable High Court in writ jurisdiction.
Yes.
And my lord kindly comes to page 47, wherein, my lord, a coordinate bench of this Honorable Court passed, my lord, disposed of the writ application and passed necessary orders. My lord kindly comes to page 47. I'll go to the last paragraph. Learned counsel appearing on behalf of the state relies on the report. Steps have been taken during investigation, including seizure and examination of witnesses. Notices were issued under section 91. Prayer was made to obtain documents from BLLRO and the office of sub-registrar of Alipur. Shortly, a report in final form would be filed. Now, it is quite indeed quite surprising that for an FIR that was registered on 3/7/2021, till date, neither a charge sheet nor a final report could be filed. Let the further investigation of the case be continued, albeit under the supervision of Assistant Commissioner of Police, Belgoria, Barakpur Police Commissionerate. Let the investigation of the case be concluded expeditiously and in accordance with law. Thereafter, my lord, what happens? A final report, my lord, a final report is filed by the investigating agency at page 49.
Yes.
Describing, my lord, that the dispute is civil in nature.
Yes.
Civil in nature. Be
Page
that
49.
Yes, page
Yes.
49, the very next page.
Yes.
Civil in nature, my lord, be that as it may. Be that as it may. Now, kindly comes to the order sheets, my lord. Kindly sees what happens thereafter, which is really surprising. Kindly comes to page 50 onwards. Page 50, my lord, is the certified copy.
Page
50, 50, my lord.
Yes.
Yes. Page 50, my lord, is the order sheet. Now kindly turns to page 51.
Yes.
90 order dated 19th April 2024. Seen the FRT number 94 of 24 dated 4/3/24 under section 420, 468, 471, 120 BIPC. Issue notice to de facto complainant for his opinion. This is the settled law, my lord, that a notice has to be issued to the complainant, inviting him to come and file his protest petition if at all is interested. Now kindly comes to the next date, which is, my lord, 13/5/25/24, Hazira filed by accused persons. No SR of notice from PS. No SR of notice from PS. This is also in accordance with law. Kindly comes to the next order, my lord, at 23rd July 2024. 12 accused are on bail and absent petition filed by learned advocate on behalf of 11 accused. Accused number 1, Shatrajit is present, filed by Hazira. No SR of notice has yet been received from PS till 13:30 hours. Issue fresh notice to de facto complainant. Fix 6/11/24 for SR. Now, my lord, the last order. The next page. This is 6/11, my lord, 2024. No SR of notice. De facto complainant is struck off. It is the accused Shatrajit Mitra is present, filed by Hazira along with track report. He is an accused, my lord, kindly remembers. Along with track report and others, accused is absent by petition. None moved for de facto complainant on repeated call. Postal track report is sufficient to show service of summon. Hence, FRT is accepted, case is disposed of. My lord, how can the accused step into the shoes of the prosecution and file a document which should never be in the hand of the accused? No SR of notice is the first line of the order. Kindly sees, my lord, the order dated 6 November. It starts with the endorsement that there is no SR of notice. And towards the end, my lord, FRT is accepted because a track report is filed by the accused person. He is not even in a position to issue notice. I am the de facto complainant. I got to know about it 7 months later while I've been going to my lawyer's chamber.
Learned advocate for the petitioner is present. This application is directed against the order passed by learned ACGM at Barakpur in GR 5542 of 2021 in accepting the FRT submitted by the investigating officer without granting an opportunity to give the views of the de facto complainant. Upon perusing the petition and considering the facts of the case, this court is of the view that this application should be admitted. Let notice be issued upon the opposite parties within 1 week and affidavit of service be filed. Let this matter appear 2 weeks after vacation.
My lord, kindly stays the operation of the order.
No, let the matter appear. Whatever you see will be the decision that will be binding.
Well,
Item number 11.
grateful.
12.
Yes, my lord, I am appearing on behalf of the petitioners. My lord, quashing of the entire proceeding, wherein charge sheet has been submitted under section 341, 323, 506 and 34 of the Indian Penal Code, and subsequently section 195 capital A of the Indian Penal Code has been added. Now, my lord, 3 petitioners are before your lordships. Petitioner number 1 is a boy, and petitioner number 2 and 3, they are the parents of petitioner number 1. Opposite party number 2, she suddenly started claiming that the petitioner number 1 is the husband, is her husband. That means husband of opposite party number 2. Initially, 498A, 307, 324 of the and 34 of the Indian Penal Code that was started. And my lord, subsequently, they were discharged from this allegation, and the final report stating mistake of fact was issued in favor of these petitioners. My lord, kindly comes to page 204 straight away. Page 204. My lord, top portion, charge sheet not submitted, final report submitted stating mistake of fact.
Page 204.
204. But my lord, the most relevant part is in page 206 and 207. In 207 specially, my lord, kindly comes to page 207.
Yes.
Second paragraph I am reading. Hence, the allegation made by the complainant in his complaint is totally false and fabricated one. It was simply a self-made complaint plotted with a view to malign and implicate the other side, which is absolutely an afterthought story, particularly when she herself is dubious by all means. Not only that, next paragraph, my lord, it is in the last but 3 lines from bottom. I am reading. This case, it starts with from this case with a prayer for necessary order may kindly be passed to submit prosecution under section 182, 211 in the IPC against the complainant Bachendri Rai and false witnesses, namely Mehraj Mullah alias Liton and Shamimuddin Mullah, Shayon Chakraborty and Raja Bhattacharjee in connection with this case. Or that means, my lord, false witnesses were brought and she was trying to establish a case under section 498, 307 and 34, 506 of the Indian Penal Code. But my lord, subsequently...
So this report, the FRT was submitted.
Yes. But my lord, when the girl, she understood that her complaint was not enough to incorporate these petitioners, she came with a new complaint. That is in next page. My lord, kindly sees next page. A new case was started under section 341, 323, 506 and...
That was on a separate complaint.
Yes, separate complaint. And I have come before your lordships with this separate complaint. My lord, kindly comes to page 209. This is the written complaint. My lord, her allegation is when she was coming back from Barashat court, after meeting her lawyers or attending court, my lord, these petitioners, means the boy with his parents, they attacked her and my lord, she was assaulted. I am reading, my lord. Kindly comes to the middle portion of
Yes, yes. FRT 632, 498, 307, 324. This is there.
Yes.
With the DIRCON to withdraw the pending criminal case.
Yes. Page 209. Your lordship is reading page 209.
Yes, 209 in the middle portion.
Thereafter, threatened me with dire consequences to withdraw the pending criminal case being FIR number so-and-so, dated so-and-so, at Muddumgram PS under section so-and-so, saying that if you don't withdraw the case, you will have to lose your life and family members of yours. So-and-so be able to lead a safe life and in near future. Niladri and his parents also hurled abusive and filthy languages at me, and Niladri slapped on my left cheek and launched
and pounced on my nose. As a result, I was bleeding profusely from within my nose and left side of my cheek below ear, since I received grievous injuries of those body parts. Now, my lord, in this case, my lord, charge sheet has been submitted. 207, I have annexed all the copies. If your lordship sees 207 copies, your lordship will find in this case also another, some other few witnesses were brought who were not present over there. They did not see the incident, but they have stated they knew the fact. Kindly comes to page 210 first. This is the 161 statement of the de facto complainant. Here it is stated in middle portion, ইংরেজি 3/8/23 তারিখে
No, this you see, this complaint, okay, that is 3/8/2023 is lodged after this charge, this FRT is submitted.
No, my lord. Before FRT was submitted, but she understood that her complaint as well as 161 statements are not enough. Thereafter, to incorporate
What
this
did the IO collect? Any injury report collected?
injury report in this case,
Yes, I also tried to collect injury report.
my lord, if your lordship sees the 161 statements, kindly sees the 161 statements are also not enough. My lord,
that is
page 211. Page 211. I am reading. কিন্তু মধ্যমগ্রাম থানা তদন্তকারী অফিসার তিন্নি গাঙ্গুলি এবং তার বাবা অরূপ কুমার গাঙ্গুলির নাম বাদ দিয়ে চার্জশিট দেয়। সেই কারণে ইংরেজি 3/8/23 তারিখে বাচেন্দ্র রায় বারাসাত কোর্টে নারাজি পিটিশন দিতে যায়। কাজ শেষ করে বাচেন্দ্র রায় কোর্টের পেছনে দরজা দিয়ে বেরিয়ে যাচ্ছিল। সেই সময় বাচেন্দ্র রায়ের স্বামী নীলাদ্রি দত্ত, শ্বশুর স্বপন কুমার দত্ত, শাশুড়ি ছবি দত্ত মিলে সেখানে এসে বাচেন্দ্র রায়কে উদ্দেশ্য করে অকথ্য ভাষায় গালিগালাজ করতে থাকে। বাচেন্দ্র রায় প্রতিবাদ করলে ওরা বাচেন্দ্র রায়ের উপর চড়াও হয়ে তাকে তিল চড় ঘুষি মারে এবং প্রাণনাশের হুমকি দেয়। এই ঘটনায় বাচেন্দ্র রায় আহত হয় এবং বারাসাত সরকারি মেডিকেল কলেজ এবং হাসপাতালে গিয়ে চিকিৎসা করায়। আসামিদের আইনানুগ শাস্তি হওয়া দরকার। But she did not say that she has seen the incident, where from she collected that news. He has not stated. Thereafter, page 212. And my lord, this witness in page 211, he gave the witness into a 498A. I have read that particular portion wherein the name of this witness was there. Kindly comes to page 207 once again. All these witnesses are her pocket witnesses. Kindly comes to page 207. Shayon Chakraborty. And I have just read the witness of Shayon Chakraborty 211. Kindly comes to page 207 first.
207.
Yes. Kindly sees the last line. False witnesses, namely Mehraj Molla, Liton, Shamsuddin Molla, Shayon Chakraborty.
So some of the witnesses were examined in this case also.
They are the false witnesses. My lord, kindly sees. It is stated by the IO that false witnesses, namely Mehraj Molla alias Liton,
Yes.
Shamimuddin Molla, Shayon Chakraborty, and he is that Shayon Chakraborty.
Only thing is the IO did not collect this injury report.
There was no injury. Why there was no injury, I shall state, my lord. My lord, this is Shayon Chakraborty. Thereafter, kindly comes to 216. 216, another false witness. 216, he is Raja Bhattacharya. This Raja Bhattacharya was the same Raja Bhattacharya who gave false witnesses as per the charge sheet of 498A case. This is the same person.
No, he is mentioning about charge sheet submitted with regard to the earlier case.
Yes. My lord, I have annexed the charge sheet also. There is no whisper of any injury report. If your lordship sees page 218, page 218, I also try to collect injury report of injured Bachendra Rai from Barashat.
So the place of incident is just outside this,
outside of Barashat court.
outside the court premises. This is the place of incident.
Yes. No disinterested witness was there. On the other hand, the pocket witness of this girl, who were declared as false witnesses in the charge sheet of 498A case, they came forward to give again false witness. My lord, in this regard, my
So
lord,
that 324 in this 2024, the earlier case FRT was submitted. Okay. And this case was instituted
on
in
August 2023.
2023. So after submission of the FRT, then this question came that Naraji petition and all these things.
Yes, but my lord, in the Naraji petition,
2024, after 2024.
in the Naraji petition, in the final report, it was stated that Sayan Chakraborty and Raja Bhattacharya, they were the false witnesses. And that Sayan Chakraborty and Raja Bhattacharya again came up to give false witnesses. Now, my lord, in this regard, I shall submit before your lordships a list of cases. My lord kindly appreciates this girl at least filed 5 to 6 other 498 cases against different persons. Kindly see the list. 21 cases are pending in this honorable court, my lord. Different persons, they have, my lord, come before your lordships to get their protection from this girl. Kindly see the list, my lord. Kindly see the list. Different, my lord, she has
present
an
the
habit
case
of-
is under case which is the charges against you are 341, 323.
Yes. No injury report has been collected.
506, 34 and 195. You are on bail.
Absolutely, my lord. We were on bail. Not only that, my lord. I lodged a case, my lord, against this girl for collection of false documents, false marriage registration certificates, wherein she was arrested and she was in custody. My lord, she has lodged 7 cases against 7 persons under section 498A. She has an habit of claiming different persons as her husband.
Yes. Lord Mr. Chatterjee, learned advocate for the petitioner, is present. Learned advocate for the petitioner. Here is the petition filed and materials on record. This petition is filed seeking washing of GR case number washing GR case number 4720 of 2023 arising out of Barashat police station case number 554 of 2023 dated 3/8/2023 pending before learned second judicial magistrate Barashat North 24 Parganas. Learned advocate for the petitioner draws attention to the case instituted by the de facto complainant opposite party number 2, wherein pursuant to investigation, it was observed that the case is a false case and some of the witnesses were alleged to have given false evidence. Learned advocate further draws attention to the statements made by the witnesses of this case who earlier were witnesses of the case in which the petitioner, the present petitioners were discharged on the report of FRT. So that case has come to an end.
Naraji filed. Oh, Naraji filed and Naraji was also rejected.
So
yes, that was the
case
end.
Learned advocate further draws attention to the materials on record and submits that this de facto complainant has a habit of lodging different complaints against different persons. Top. It also appears from record that no injury report is collected by the investigating officer, although he has stated that he is trying to collect the injury report. Upon perusing the petition and upon hearing the learned advocate, this court is of the view this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties, and within 1 week, an affidavit of service be filed. let this matter appear 2 weeks after vacation. Pending hearing of this application, let there be a stay of further proceedings of GR case number 4720 of 2023 pending before learned Second Judicial Magistrate Barasat North 24 Parganas for a period of 3 weeks after vacation.
Grateful, my lord. Grateful. Grateful.
Patel. Time for the defective complaint and opposite party number 2.
It's a motion stage, my lord. I think he doesn't have any right to address the court as of now. No, here. फर्स्ट पे बोला फर्स्ट वाला बॉलिंग बॉल कर दो हमारे पास छोड़ दीजिए ये भी है
कैसा चाहिए
डिस्टर्ब कर दी ये कहां है
क्या तुम लोग
सजा के रखे हो
Yes. Cases under which sections?
Lordship, the cases are under section 420, 405 of the Indian Penal Code, 63 and 65 of the Copyright, and 130 and 104 of the Trademark Act 1999. This is a dispute between the partners who also happens to be the relative. My client is the 50% partner of a partnership firm running the business of a dentifrice that is called a ghoul. And the other two partners are my sister-in-law and my nephew, who is having a 25% share in the partnership, Lordship. Now, what happened, Lordship? It's a checkered history, Lordship. What happens? There is a dispute started when this particular firm, Musa and Company, they were manufacturing the ghoul and they were also giving royalty to different family members. Now, the other royalty given to other family members, including the husband and the other nephew of the other two partners, and also to the other brothers, that was not disputed. But my client, when he gave a royalty to his wife to sell the product and use the product trademark, dispute started, Lordship. Now thereafter, the other two partners filed an application because of the arbitration agreement. So they took out an injunction application under Section 9, which was granted. Appeal was carried on. That was also allowed. That I was restrained. What my client, being a 50% partner, being totally upset, he decided to dissolve the firm. So he exercises the right under Section 43 of the Partnership Act, dissolve the firm by giving a notice on 17 November 2018. Lordship, just a little 5 minutes, Lordship. So partnership, we dissolve. The other two partners did not agree with the dissolution. They invoked the arbitration clause. Learned arbitrator was appointed. Now, the learned arbitrator, when he was conducting the arbitration, we took out a point that, look, we have dissolved the firm. Please decide that first issue, whether the partnership is at all in existence or it has been rightly dissolved. The learned arbitrator, by his wisdom and
in the presence of the parties, all the parties, including the defective complaint.
Yes. The learned arbitrator held that partnership was as partnership at will, and it has been rightly dissolved with effect from 17 November 2018. These dates are very important. Now, that order was challenged by the other two partners under Section 34 before the Honorable High Court. The Honorable High Court, after hearing the parties on contest, found actually one thing more. There was a 10 lakhs rupees cost imposed upon the other two partners also by the learned arbitrator. As for arbitrator, Mr. Sham Sarkar. Now, when the matter was taken up for hearing on Section 34, my Lord Honorable Justice Moshambi Bhattacharya upheld the dissolution that it has been rightly dissolved. So the partnership stand dissolved with effect from 17 November 2018. Only consolation was that the 10 lakh rupees cost was reduced to 5 lakh rupees on their prayer. They made a request, that is a huge cost, kindly reduce that. So that was reduced to 5 lakh rupees. They preferred an appeal under Section 37 with the Honorable Division Bench. Honorable Division Bench
has also held that the partnership, because he said we don't disagree with the order passed by the learned single judge. Only Honorable Division observed that there was some observation of the arbitrator that should have not been observed in the award, but that partnership has been rightly resolved with effect from 17 November 20, all of annexed with my application. That matter was again challenged by them in the Supreme Court in an SLP. SLP was dismissed. My lord held that we are not inclined to interfere. The order has been rightly passed. So up till Supreme Court, it has been held that the partnership is dissolved, stands dissolved from 17 November 2018. Now the arbitrations are going on. Parties are contesting.
Now arbitration at present.
It's going on. Now it's at the evidence stage. Now what happened, Lordship? Just see how the vengeance are wreaked, Now what happened, Lordship? That two things, Lordship. Again, during the arbitration, there was an issue raised whether that it was an interim award in nature, whether the partnership has been dissolved at all or not. Again, the matter went to under section 34 before the Honorable Justice Shobhasachi Bhattacharya. He again held, yes, it has been dissolved, and there's no question of interfering with the finding of, because it has been till Supreme Court, it has been carried on, and there is nobody has touched that observation on the order of the passed by the learned arbitrator. The matter was again placed in a division bench. The division bench is also, there is a finding that regarding the dissolution of partnership, it is final. Now see the FIR.
Yes, let us consider the complaint. Yes, which bench?
Lordship, the FIR is on page 183 to 197, Lordship. Kindly come to page P11. এটা হবে volume 2. 2 mat le do. Now, Lordship, may kindly see the formal FIR appears from 183. Lordship, may kindly see the date of the registration of FIR is 22nd October 2020. This is post-dissolution. And who lodges the FIR? You see who is the complainant, Lordship. Kindly come to, Lordship, got it 183, Lordship.
183.
Volume 2, Lordship. This is volume 2, 183, Lordship. Kindly see the Domjur PS case 551, 2020, dated 22nd October 2020. So if you see the date, this is post-dissolution, because my dissolution is with effect from 17 November 2018. Now, Lordship, may kindly see who is the complainant. Next page. 184, clause 6, name of the complainant. Partho Pratim Shannal, authorized representative of Messrs. Musa and Company, this company. This company did not exist at that time. And this is a company where I was also erstwhile partner, 50%. Can you see next way, 184, clause 6, Lordship? Now, Lordship will find, if you Lordship want to see the order of the Supreme Court and High Court, I can show you the annex with all with my application.
Those are with regard to that arbitration section.
Arbitration and is dissolved from 17 November 2018.
Let's consider this.
Yes, Lordship. So my first and foremost point is that this proceeding, the criminal proceeding, initiated by the partnership firm, which was not in existence.
Okay, let us see.
That is first point, Lordship, which I have showed you, Lordship, the date of the FIR, and I have showed you my dissolution. If you, Lordship, want to see my dissolution, I have annexed the application on 163, page 163, 164, page 8. And the interim award, where the learned arbitrator held, it has been rightly resolved, is on page 199 to 221. Kindly come to that part, Lordship.
Investigation is continuing, or is
no,
it completed?
Then what happens, Lordship? The IO submits final report.
199. Yes.
Page 253. 199 to 221 is the interim award by the learned arbitrator holding.
No, 185 is the complaint. Let us see.
Lordship, kindly come. He starts with, this is to inform you that I am an authorized representative of Mohammed Musa and Company. When he's starting this? On 22nd October 2020. When he knew very well that this was not in existence. And then he comes with a complaint that this was a partnership firm and the other partner has usurped and he has given to his wife such and such. He make this contention. There was section 9. So there was an appeal. Thereafter, if you see, Lordship, may kindly come. He admits in page 189, despite claiming to have dissolved the firm on 17 November 2018, Mukhtar Alam will continue to illegally manufacture tobacco gul under the such and such. So he admits that there is a dissolution. Then he says about the various proceedings in the High Court, there was one contempt application filed which is still pending. Thereafter, Lordship may kindly see. He completes the complaint on page 192. 420. I being a partner, S1 partner, I am also holder of 50% trademark. So I am committing the breach of partnership and I am also committing the infringement of my own trademark.
So now
Page
the question is, he in the complaint petition, he does not, you see, suppress regarding that arbitration proceedings and the.
No, he is not suppressed, but he cannot act as an authorized representative of the firm which is not in existence. Now, what the IO did, kindly see, coming on to page 253, Lordship. The IO meticulously files a final report. Page 253, page 18, Lordship.
Page 253.
253. Now, his finding, Lordship will find from page 256.
Yes.
During investigation, the complaint was examined. Place of occurrence was visited. Rough sketch map with index of PA was prepared. Statement of witnesses under section 161 of the CRPC was recorded. Raid search was conducted into the place of occurrence, factory on 24th October 2020, and seized many articles under proper seizure list and sealed the factory gunpowder under lock and key with proper seals by the previous IO Sub-Inspector Mr. Onimesh Das. Thus, the accused has complied the notice under section 41A of CRPC, thereafter surrendered before the learned CGM Howrah on 2nd December 2020, and the bail was allowed. That thereafter, State Sub-Inspector Mr. Onimesh Das transferred, and the matter was handed over to me for further investigation and proceeding. The learned advocate of the alleged person have communicated the order sheet of the Honorable High Court, other relevant documents. So I think that is not a wise to drag investigation anymore. That the case was further investigation by me from this fact, the fact and circumstances and evidence collected by me. So far, it came to light here that Mukhtar Alam was a partner having 50% of share in a partnership firm, namely Musa and Company, having its registered office as such and such Zakaria Street, Kolkata 73. He is also owner of 50% share of the trademark, being number such and such. That in the said partnership firm, namely Mrs. Musa and Company, then the other two remaining partners are namely Yasmin Khalik, wife of Mohammad Khalik, and Mohammad Shahid, son of Mohammad Khalik, being the owner of 25% share each. That the said partnership was formed on 1st April 2006 and is the nature of partnership at will. That though the said partnership is formed in the year 1992, but subsequently a fresh partnership deed is executed on 1st April 2006, wherein Mukhtar Alam held 50% partnership share and Yasmin Khalik and Mohammad Shahid 25% share each. That the partnership firm from time to time granted license to other family members in a very nominal royalty to use the registered trademark and carry on manufacturing of a tobacco gul by forming different firms and companies. Accordingly, the firm granted license to Mrs. Industries, a partnership firm consisting of a partner, namely Mohammad Khalik, Mohammad Danish, Mohammad Nazish, and Mrs. Zoya Shahid. These are all the family members of the other two partners. The firm also granted license to Mrs. MI Tobacco, the directors, Mohammad Khalik. Again, Mohammad Khalik, the husband of Yasmin Khalik. Mohammad Danish, Mohammad Nazish having his office at 26 Zakaria Street. The firm further granted license to Mrs. JS Industries, a partnership firm, partner, namely Iftikhar Alam, Imtiaz Alam is our brother, family member. Since the said Musa and Company granted license to other family members of late Mohammad Subedar, hence the license was created in favor of Mrs. MS Industries having its office at 53 Fairs Lane, Kolkata, and factory situated village Pakuria, Lakhanpur Police Station, Domjur, Howrah. The disputes and differences are between the parties Musa and Company, when Yasmin Khalik and Mohammad Shahid took out an application in Section 9 of the Arbitration and Conciliation Act 1960, thereby praying for interim measure in the Honorable High Court at Calcutta, which was registered as AP numbers 22 of 2018 on contest with Lordship Honorable Justice Ashish Kumar Chakravarti passed an order of injunction against Mukhtar Alam and on 3rd October 2018, thereby restraining him from carrying on parallel business of similar nature either by himself or through his agents or assignee or nominees or otherwise, however, from running parallel business of manufacturing or dealing with or selling Musa Gul by the name of MS Industries. That the said order was upheld by the Honorable Division Bench of High Court Calcutta on 15 November 2018 in appeal. That since the nature of partnership firm, namely Mrs. Musa and Company, was a partnership at will, hence Mukhtar Alam being the partner having 50% share exercised his right and dissolved the firm by a notice dated 17 November 2018 under Section 43 of the Partnership Act. That the other partners, that the said Yasmin Khalik and Mohammad Shahid, approached the Honorable High Court at Calcutta by filing an application under Section 11 of the Arbitration and Conciliation Act 1996, pin AP number 6/21 of 2018, and on 26/11/2018, His Lordship Honorable Justice Ashish Kumar Chakravarti, after hearing both the parties, were pleased to dispose of the AP number 6/21/2018 and have appointed Mr. Shyam Prasad Sarkar, Senior Advocate of Bar Library Club, as the sole arbitrator to adjudicate the disputes between the parties relating to the partnership deed April 1, 2006. That thereafter the arbitration proceeding began, and after 39 sittings, the learned arbitrator passed an interim award on 12th November 2020, thereby holding that the deed of partnership of the partnership firm Mrs. Musa and Company dated 1/4/2006 is a partnership at will, and the same stand dissolved consequent upon service of notice dated 17 November 2018 by the respondent, that is Mukhtar Alam, on the claimant, that is Yasmin Khalik and Mohammad Shahid, that the Yasmin Khalik and Mohammad Shahid filed an application under Section 36(3) and Section 34 of the Arbitration and Conciliation Act, being AP number 359 of 2020 and GN number 1 of 2020, for setting aside the interim award dated 12 November 2020 passed by the sole arbitrator, by which a deed of partnership dated 1st April 2006 of Mrs. Musa and Company, a partnership firm, was declared to be a partnership at will, and partnership firm was further declared dissolved consequent to a notice dated 17 November 2018. That is Lordship Honorable Justice Maushami Bhattacharya on 25th March 2021 dismissed the AP number 359 of 2020 and GN number 2020 and upheld the impugned award dated 12th November 2020. That Yasmin Khalik and Mohammad Shahid again approached the Honorable High Court, Calcutta, and filed an appeal under Section 37(1)(c) of the Arbitration and Conciliation Act 1986 against the judgment and order dated 25th March 2021, being APO number 70 of 2021, and their Lordship Honorable Justice I.P. Mukherjee and Honorable Justice Anuradha Rai passed the order on 1st July 2021. The Honorable Division Bench did not grant stay of the order dated 25th March 2021, passed by His Lordship Honorable Justice Maushami Bhattacharya, which has upheld the dissolution of partnership firm, namely Musa and Company, with effect from 17 November 2018. That passing of the interim award dated 12 November 2020 and judgment by the Honorable Maushami Bhattacharya on 25th March 2021 confirmed that Mrs. Musa Company, a partnership firm, stand dissolved with effect from 17 November 2018. Hence, the de facto complainant, Mrs. Musa and Company, represented by one Parthosh Parthim Sanyal, has lost locus due to such dissolution of partnership firm. However, the FIR has Section 420 of the Indian Penal Code, that from the written complaint treated as an FIR, I find there is no ingredient of Section 420 of the Indian Penal Code.
Who is the accused in this case? Petitioner Mukhtar.
Petitioner Mukhtar is 50% partner.
Mukhtar Alam, that is the accused in this
Accused,
case.
yes. But sister-in-law and nephew on one side, 25%. I am the 50%. Now, this FRT was filed and it was challenged by way of a Naraji petition. Now, the Naraji petition, in the Naraji petition, the learned
Anyway, this was not accepted, and there is a direction to cause further investigation.
So, first, initially, the learned CGM did not consider the Naraji petition, the
Now,
final report.
Let us see that order. The
Last
order
order,
passed in that Naraji petition.
The first order, Lordship. There are two orders, Lordship. Page 272.
No, which order you are challenging?
Oh, I'm sorry. The MP order is in the page 818. Lordship, volume 5. I'm so sorry. Because the volume is because of the arbitration and several litigation. But Lordship will find the order which begins after page 888. This is certified copy of annex with the last annexure to my application, not paginated, because I was not, but the original certified copy is there.
Anyway, continue tomorrow. Yes. Record an order. Learned advocate for the petitioner submits but could not conclude the submission. Let this matter appear on 10/9/2025. It's under the heading to be mentioned.
It will be at 3 o'clock, Lordship.
Yes, normal 3 or after original site, whichever is earlier.
Whichever is earlier. Grateful, Lordship.
Before Lordship writes,
Yes.
item number 28 and 38.
Yes.
These are two applications for expedition placement.
Okay, tomorrow I shall see if it can be taken up.